Capital number 827 2020. Listed for admission.
Yes, sir. Indication.
You know, 12 year in custody.
Yes.
Fresh one. Thanks.
Business. On that one, has gone to attendance packets item number 17 and 20 to 24 is any other.
Just you wait till we see that.
Supplemental list, item number 1.
Pursuant to Lordship direction, the Secretary Outlet Development Authority is present for Lordship. And with your apology, I just want to communicate this on court. So far as opinion number 1 is concerned, the grandmother has expired and he has gone to Pune to attend the rituals. So he's not joining us.
This is the case where the SLP is dismissed.
Yes.
Thereafter, you move modification application.
Yes, there also I have to make a submission.
But modification application is now rejected.
Yes, yes, yes.
Yes, why have you not complied the order?
Yes,
Who is appearing?
What is his name?
Secretary, Raukla Development Authority.
What is the name?
Name?
Or Mamat, Lankeshwar Amat.
Balkeshwar.
Lankeshwar Amat.
Contempt number 2.
Open number 2.
Lankeshwar
Amat.
Who is he?
He's the Secretary at the Raukla Development Authority.
Yes, why have you not complied the order? Mr. Amat.
And my lord, the Supreme Court जो SLP टा सर dismiss ହେଲା 20/1/25 रे सर एवं आमे सर पाइलु ऑर्डर टा 24/1/25 रे एवं 24/1/25 रे ऑर्डर पाइला परे सर आमे दोकानी मानकु सर एविक्शन करिया पई नोटिस दनु 29/1/25 रे सर ऑर्डर टा को आमे सर कैरी करू छ सर पालन करू छ सर एवं सेति पई मध्ये अल्टरनेट स्पेस मध्ये सर आमे आइडेंटिफाई करिछु एडीएम
Affidavit I had filed was I am extremely sorry because I had not done the annexures. I am very sorry for that, and that has been rejected by our lordship. I can file an objection plus again. And one thing was I am just bringing to lordship kind notice.
When you will comply the order, we will not hear anything.
No, in the event it cannot even be complied because a stay order has been procured.
Then you will go to jail.
Plus,
you will go to jail. We will send him.
This Court has stayed the process of eviction.
We are sending him to jail.
Yes, you also can see this order.
On the order has been of this court, which has been confirmed by the Supreme Court in the SLP, and review petition has been dismissed. And you have he has dared to say that I will not comply the order.
No. So he plus then come. Apan ko comply karibani boli kahile.
नहीं सर, हमें सर comply.
I file the affidavit. You appear tomorrow and file the affidavit. We are taking up this matter tomorrow. File the affidavit that when you will comply the order. The Lankeshwar opposite party number through appears through virtual mode as per the order dated 6/5/2025. The Mr. Katkiyal and counsel for the petitioner, contender opposite party submit that due to some personal difficulty, opposite party number 1 is not able to.
He's on leave.
He is on leave and therefore he was not able to appear through virtual mode. Put up this matter on 12th of May 2025. An affidavit for date of compliance of the order shall be specifically filed by both the opposite party, and both of them shall appear through virtual mode on 12th May 2025 at 10:30. Yes,
So will your lordship will please.
will not hear anything. Yes, next.
Oh my gosh.
Item 2,
Affidavit has been filed, compliance affidavit. The copy has been served.
Well, in sub item 2, that is not related to this case, man. That is a wrong way listed. Actually, that number
Where is that
is.
compliance affidavit?
Flag X.
Compliance affidavit has been filed by the opposite party, Contempt. Accordingly, the contempt petition is dropped. This is so far as number 1 is concerned.
Which you second as it not related to this.
No, that is also a contempt petition.
But that is not.
Direction in the
Acha.
5629 the toilet touch.
You want it to be separately listed or what?
Yes, ma'am.
Acha.
No way to discuss.
Single bench case.
It's a single.
It's a single bench case. And what about the other one?
Other file is comprehensive file is so this Kali file is.
Single bench. Baki jati karo.
No. Go to second house single bench. Back
Acha, contempt petition number 5269 of 2024. The London Council for the state submits that this is not connected to contempt petition number 5656 of 2024. And it's also a single bench matter. Stop. In view of the submission, list this matter before the assigned bench. Stop. Then contempt petition number 5594.
Yesterday we have filed the compliance affidavit. A copy has been sent.
Compliance affidavit not received like that.
Kali filing day.
CONT number 5595 of 2024, with I would have like to oblique to see contempt petition number. Dita file for the
Again.
contempt petition number, it is separately list 5629 of 2024. The London Council for the state submits that compliance affidavit has been filed yesterday. Filed yesterday. Put up this matter on 13th of May 2025 with the compliance affidavit. As I it is submitted also by the state that the copy of the compliance affidavit has been sought on the London Council for the petition. Okay, now put up this matter on 13th of May 2025. Okay.
item 3,
My lord, I'm very sorry, Your Worship. On that day, I submitted something that it will be deposited. But unfortunately, my lord, what has happened, since it's a matter of 2002, and in between there are lots of difficulties that the PI of Barampur has been resolved and that has been bifurcated, Your Lordship. That it will under the
National Highway shall file an affidavit by tomorrow.
Yes,
Indicating before whom the money
my lord.
which was supposed to be paid has been deposited.
It was supposed to be paid as per the rules, Your Lordship, to be for the competent authority, Your Lordship. We have wrote the letter to the competent authority on 6th of May. They are saying that they are the
Mr. Council, you are supposed to file an affidavit.
My lord.
Have you filed the affidavit?
Yes, I have filed an affidavit.
What have you stated?
I have stated, my lord, because of
Let's come to that affidavit.
my lord, I am saying that. Yes, I have stated, my lord, Your Lordship is directed to file an affidavit that whether the amount is deposited, that we have written letter to the competent authority, Quincy, who has referred this matter for under section 3H, Your Lordship, for enforcement. But the authority wrote a letter and replied us that they don't have they are not, the records are not traced out, Your Lordship.
You made a submission
My lord.
on
Yes.
6/5/25
My lord.
that the money has already been deposited.
My lord,
That is how we have mentioned in
yes,
that order.
yes, yes. Therefore, I'm saying that
So now you are going back from
no,
the
I'm not saying
statement.
that. Therefore, I said I'm sorry, Your Lordship. I try to convey that it is per the rules. It is to be deposited before the competent authority. Therefore, the apportionment has been referred to the decisions, Your Lordship. But because of this long gap, Your Lordship, and in between the PI of Barampur was resolved and it has been bifurcated. It is one to PIO Visakhapatnam, then again PIO.
In the para 4, you have said that.
Yes, sir.
But you are saying that the record is the payment.
Yes, your lordship.
Particulars regarding the payment
It
is not traced out.
Traced out.
Whether you have deposited or not, that is
So I couldn't find out. But my lord, this payment has not been made. If your lordship may kindly direct, if your lordship may
Yes, subject to lordship permission, I can explain the issue. As per section 3H4, the Kala is supposed to deposit the amount before the court and refer the matter to the decision for taking a decision of apportionment of the compensation amount. So far as this case is concerned, I think here the Kala has not deposited the amount. That is, even if he has not deposited, he has to pay as per the direction of the decision. Therefore, I am suggesting subject to my permission, lordship, dispose of the matter direct in the Kala and PT. To dispose the compensation amount along with
again, it will be hanging in there.
No, my lord. Because time limit will be 1 month.
Sorry.
My lord.
Deposit appear through virtual mode when you will deposit
Yes.
that amount. For this type of latches from the other side, the people are running to the court from time to time.
My lord.
We will make a submission, within a month we will deposit and we will dispose of, then we will not deposit, we will come again, file a contempt petition, again that will be extended, second contempt, so this will not allow.
My lord, give some time at least.
We are just keeping this matter next week. You do whatever you want to do, but give us a positive statement, right? As for the order dated, as per the previous order, the Land Council you are for the opposite party number 4.
My lord.
Opposite party number 4, who has already filed an affidavit, submits that the matter may be taken up next week in order to obtain some material instruction. Put up this matter on 14th of May 2025. Yes.
Item 4.
May I prepared a date chart because the date charts are somewhere annexed to the my lord, my repetition is not properly done. I prepared a chronological my lord, date chart lordship. This is regarding I have challenged my lord the decision of the competent authority, land acquisition officer Puri, in not extending the benefit as per the statutory provision. As per the statutory provision, the market value has to be paid as per the section 26 to 30 my lord, which includes solatium 100% and
What is your
4%
prayer in this writ petition?
prayer my lord, I passed my lord annexure.
8.
Page my lord, page 118 my lord. The order dated 10/5/24.
Annex 8.
Page 118 my lord, 118. May I place that?
Yeah.
This case is taken up today.
This is the order which you are challenging.
This order, madam. This 10/5/24.
Okay, yeah.
This case is taken up today. The notification 4(1) of the Arbitration Act, so 13th of the project extension of Musa Rivers, phase 1 was published by notification dated 21/10/25 for the following schedule of land. The notification 11(1) of the Arbitration Act for the above scheduled land, published by notification number 12/5/22. The declaration under section 19(1) of the Act of the above schedule of land was published by the appropriate government by declaration dated 16/8/2023. Survey section 12 of the Act was conducted in the presence of the affected persons. The scheduled land was marked out and measured from the survey report. It is found that there is no structure standing on the scheduled land. The applicant has submitted the ROR, copy of the suit land and prayed for land compensation amount in his favor Peru. Sanjay Kumar Mahapatra is present for hearing under section 21 of the Act. He prayed to award LA compensation as per the corrected ROR issued by the Tahsildar Puri based on OLR 88 case 312/2019. He has also demanded at least 20 lakhs for decimal valuation of his land. His grievance as submitted during hearing process was although the kisam of land was converted by order converted by the above mentioned OLR 88 case in 2019 and the corrected order issued in his favor on 11/3/2020. However, the land earlier kisam before the conversion, acquisition and issued on mentioning kisam of land as Sarada Dui, the earlier kisam of before conversion, the period section 20 of the RFCT of 2013, it is mentioned here that the government in R&D department, by their letter number so-and-so dated 17/12/2019, was issued instruction to all collectors to direct their Tahsildar to remain vigilant while allowing the conversion of land to homestead just before or after issuance of CIA, Social Impact Assessment notification as per provisions of the Act under Section 1 of Subsection 4 of the RFCT 2013. The Works Department, Government of Odisha, by the letter number so-and-so dated 31/8/2019, was approved the said project under Abhoda scheme for the year 2019-20. The said plot was converted from Sarada Dui to Gharavali after Works Department of Odisha letter number dated 3/7/2019. The RT was converted the kisam of land Sarada 2 to Gharavali for enhancement of the land compensation amount. Then the prayer for consideration of Gharavali kisam is not allowed. No other petition filed by anyone relating to the scheduled land, then RT is entitled to receive the compensation amount in his Sarada Dui kisam. Next, my lord. In the meantime, the market value of the Mauja Sambanga has been determined by LO Puri and approved the collector, District Magistrate Puri, by the DCCSC meeting held on 23rd May 2022. On that date to be 3 crores per acre for Sarada Dui kisam of land within the project area. The multiplication factor for calculation of LA award is taken as 1 as the scheduled land is 1/1. Now, we see 1C malor. The land value has reached 27 lakhs and to solution 27 lakh. Additional 12% interest per annum on land value from the date of publication 11A to date of award for 730 days from effective. My humble submission is Section 33 regarding additional compensation says the additional compensation 12% has to be paid from 4/1 notification till date of award or possession which one is earlier. I please to move to Section 33.
That is the only dispute.
Dispute and the regarding kisam of land holding this
Land,
Gharavali.
you subsequently
prior to notification.
no. Gharavali was changed not prior to notification.
Yes,
After
madam. No,
when the notification was?
to 20 malor. 20 malor.
For notification of 20.
20 malor.
When it was converted?
Converted 19 malor.
19.
The lordship is 31 malor.
31/8/2019 is the conversion.
Converted on malor. Page 28 malor. On 17/1 to 2020. Saturday ke kudi malor.
Saturday kudi malor. So on to where the can't intended to non-intended. You were directed to deposit the following government due. So on so this conversion.
That's conversion fee.
No, this is conversion fees.
My lord, that is order 17/1 last will my lord. That order date is 17/1/2020 my lord. 17/1/2020.
You have to pay these fees. Have you paid these fees?
Yes, my lord.
Then that will be final order then. This is no. You see, this is a it is lekha hai na, as per your application for conversion of agriculture kisam to non-agriculture kisam purpose, you are hereby directed to deposit the following government dues as per the provision of 8A of the Oiler Act. So unless you deposit the money, can it be held by this letter that it has been converted?
My humble submission, I have deposited.
What is that documentary proof?
They have admitted in the order itself.
No, the date is relevant. You see, you are saying that you are supposed prior to the notification, there is a formal order issued by the government that you have deposited, and that is how it has been converted from the agricultural to that homestead land. Then you are entitled to get that. But this order which you are showing and page number 28, here the conversion fees has been stated that what is the conversion fees. The question is whether you have deposited it or not.
I have deposited it. I not said I can deposit.
Receipt from what? So
And the state has collected so from the petitioner.
How can we know?
See, in your least update which you have circulated, you have said on 17/1/2020, the state has collected the conversion fees from you.
Right.
17/1/2020.
Right.
Section 4 notification.
The 2010 2020 man. 2010 21/10/2020 page 31.
Then you have to give the proof that you have deposited.
My lord, you my lord permission.
Have you filed any document to?
My lord, they have admitted in the
Admitted nahi.
I have deposited.
In your case, you have to tell, na?
I have deposited the same before the my lord land acquisition officer.
Landing. What in the date chart submitted by the Land Council for the petitioner today, it is mentioned that on 17/1/2020, the petitioner has converted the said plot from homestead land, said plot into homestead land, filed OLR 8A case number 753 of 2019, and it was allowed by the Tahsildar Puri, while letter number 408/17/1/2020, and the state has collected rupees 27,473 from the petitioner towards the conversion fees, and the said process was completed, and the petitioner has paid conversion amount and deposited the same in the treasury of Tahsildar and in favor of the state. Stop. No documentary evidence. Nice. Stop. From the letter number 408 subparagraph dated 17/1/2020, which is at page number 28 of the writ petition, it appears that the authorized officer cum Tahsildar Puri issued the letter to the petitioner that the application for conversion of agricultural kisam to non-agricultural purpose is to be allowed subject to deposit of conversion fees of rupees 27,000, rent of rupees 270, cess of rupees 203, in total 27,473 in respect of land appertaining to Moja Samongo PS Purishadar, Khata number 2566, plot number 3908, area Ekorsun 09 decimal. However, no documentary proof has been annexed to the writ petition that the aforesaid amount of rupees 27,473 has been deposited by the petitioner with the authorized officer from Tahsildar Puri. Stop. Land Council for the petitioner submits that he will file the documentary proof in that respect. Put up this matter.
One submission, my lord. Page 26, 27. They have to come.
Put up this matter on 13th of May 2025.
Well, one submission. Obviously,
submission. Yes, next. Yes. I guess a date is relevant. ଆପଣ ଯଦି ଡିପୋଜିଟ୍ କରିଥିବେ ସେ ଯୋଉ 10/2020 ପରେ
Notification ପରେ କରିବ।
କାମ ଗଲା, ତେଣୁ ଆପଣଙ୍କୁ ଦେଖିବାକୁ ପଡିବ ଯେ କୋର୍ଟ ନୋଟିଫିକେସନ ପୂର୍ବରୁ ସେ ଅର୍ଡର ଟା ପାସ୍ ହେଇକିନି ଘର ବାଡି ହେଇଯାଇଛି ଆପଣ, ସେତିକି ତ ଦରକାର ଆମର ଆଉ କଣ ହେଲା।
ସେ ଟଙ୍କା ଡିପୋଜିଟ୍ କରିଛି ବୋଲି ସେ ଆରଟା ଦେଇ ଦେଇଛି।
whatever ନେଇ ଆସୁ ଦେଖନ୍ତୁ
ସେଇ ଟଙ୍କାଟା ଯଦି ଡିପୋଜିଟ୍ ହବ ସେଇ ଡେଟ୍ ପରେ, ସେ ଯୋଉ 4/1 ନୋଟିଫିକେସନ ପରେ, ତାପରେ ବି ଆପଣ ଗୋଟେ ପଟ୍ଟା ପାଇବେ ନା ନାଇଁ, ଘର ବାଡିର ପଟ୍ଟା ପାଇବେନି,
ଆଜ୍ଞା।
କିନ୍ତୁ ଏ ରିଲିଫ ଆପଣ ଯୋଉଟା କ୍ଲେମ କରୁଛନ୍ତି ପାଇବେ ନାହିଁ,
ନାଇଁ।
ବୁଝିପାରୁଛନ୍ତି? ସେଇଥିପାଇଁ ତାର ରିଲେଭାନ୍ସି ଅଛି।
Okay.
Yes, next.
With due acknowledgement, one moment. So that item
13/5/2025. Yes, next.
that item may be taken up on Tuesday plus. Because open will be available on that day.
All right, 13th question. So, item number one,
ବାନ୍ଧି ଥିଲେ ତ
13th. Yes, next.
Great to that.
Item 5.
My lord, I filed a petition for amendment of my prayer, and accordingly I have filed the consolidated petition there.
Your amendment prayer has been allowed.
Not
Oh. So, what is the prayer for amendment?
the prayer to change the annexure in place of annexure 8, that will be annexure 7, and dated
କୋଉଟା କଣ annexure?
prayer only in place of
prayer portion ରେ change ହବ।
prayer portion में annexure 8 ଜାଗାରେ annexure 7 ହବ ଆଜ୍ଞା।
ଆଉ କିଛି change ହବନି?
dated ଆଉ ଖାଲି dated 15/2/2022
କୋଉଟା annexure 7?
order dated annexure 7 dated 15/2/2015
annexure 7 ରେ ତ date ଥିବ, ଆଉ ଏତେ ପୁଣି dated ଟା କଣ ଲେଖିବା ଦରକାର? annexure 7 ରେ
କହିଥିଲେ ଆଜ୍ଞା।
annexure 7 ରେ annexure ଆଚ୍ଛା
ବହୁତ ଗୁଡେ order ଅଛି।
ଆଚ୍ଛା ବହୁତ ଗୁଡାଏ ଅଛି।
ଆଜ୍ଞା।
Any objection? ଦେଖନ୍ତୁ IN numbers 1, so there is an application for amendment of the prayer portion of the writ petition. After going through the interim application and hearing the learned counsel for the respective parties, the prayer is allowed. The learned counsel for the petitioner, where is that consolidated?
Yes, in file.
Fine.
Yeah.
ସେ ପେଜ ଟା କାହିଁ ଶେଷ ପେଜ ଟା ପେଜ ନମ୍ବର 6 ଟା ଦେବେ ନା
ହଁ ପେଜ ନମ୍ବର 6
କାହିଁ
ଅସଲି ପେଜ ତ ଦିଅ
ଆପଣଙ୍କର 6 ପେଜ ଟା ବର୍ତ୍ତମାନ କଢା ହେଇଯିବ। ସେ 6 ପେଜ ଜାଗାରେ ଏଇ 6 ପେଜ ଟା ରହିବ, ଯୋଉଥିରେ କି 8 ଜାଗାରେ ରହିବ 7 ଆଉ ଇଏଟା ସେମିତି ଦେଇଛନ୍ତି।
ପୁରା ଦିଆ ହେଇଛି
କନସୋଲିଡେଟେଡ୍ ରିଟ୍ ପିଟିସନ ଟା ଦେଇଛନ୍ତି। କେବେ ଫାଇଲ କଲେ? ଆଇଏଟା ତ ଅଛି, ଆପଣଙ୍କୁ ଦେଇଛନ୍ତି କନସୋଲିଡେଟେଡ୍ ରିଟ୍ ପିଟିସନ?
ଫାଇଲ କରିଛନ୍ତି?
ହଁ ଫାଇଲ କର।
କେବେ ଫାଇଲ କରୁଛନ୍ତି କହୁନାହାନ୍ତି, ଆମେ ରେଜିଷ୍ଟ୍ରି ପ୍ଲେସ୍ କରିବ। ପୁରା ରିଟ୍ ପିଟିସନ ଟା କଣ ପାଇଁ ଫାଇଲ କରୁଥିଲେ? ଆପଣଙ୍କର ତ ସେ ପ୍ରେୟାର ପୋର୍ସନ ଟା ଚେଞ୍ଜ ହେଲା, ପ୍ରେୟାର ପୋର୍ସନ ଗୋଟେ ଆନେକ୍ସଚର ନମ୍ବର ଟା ଚେଞ୍ଜ ହେଲା, କେବଳ ସେଇ ପେଜ ଟା ଦେଇଥାନ୍ତେ। ବର୍ତ୍ତମାନ ଯୋଉଟା ଫାଇଲ କଲେ ସେଇ ପେଜ ସବୁ ସମାନ ଅଛି ନା ପୁରା ଟୋଟାଲ ଡିଫରେଣ୍ଟ?
ନାଇଁ ସମାନ ଅଛି, only that portion.
କେବଳ ସେଇଗୁଡା ହେଇଛି। As a learned counsel for the petitioner submits that he has filed a consolidated writ petition before the registry, let the consolidated writ petition be placed on record and a copy of the same be handed over to the learned counsel for the state. Next.
Item 6.
Item 6.
I had a disposal for, I had a disposal for this.
Then I have just filed the affidavit along with the certificate of the order passed in FO number 19 of 2008. The last time the last order.
Last order is passed on 15/4/25. We asked you to obtain the instruction.
Just now I there.
कौन एटा अछि पोजीशन कौन?
They already appeal is ready for hearing. 28/3/2020 last page. Last order.
ठीक करो, last page टा देखो, कोर्ट टा भी मत और से करो। Change the bias to capital job.
Hearing of the appeal. It's listed for hearing of the appeal.
No, the difference is that after notification of the land acquisition,
What is your prayer in this writ
the
petition?
prayer to quash the letter order passed by the general manager, Mahanadi Coalfield Limited, that is at page 39.
Quashing the decision of the opposite party number 2 issued by letter number 180 dated 21/8/2024 under annexure 5 and direct the opposite party number 1 and 2 disburse the apportioned amount of compensation and so under law. So annexure 5 konala.
The fact is that after notification of the land acquisition,
It only says that it's only after disposal of the RFA, it will be decided, page 39.
So apportionment ବର୍ତ୍ତମାନ ଯୋଉଟା ହେଇଛି ମାନେ trial court ର that is now the subject matter of challenge in the RFA. So how can we direct at this stage that the apportionment amount which has been done, which is the subject matter, be disbursed in your favor?
but in appeal, I have stated,
No.
I am ready to punish the indemnity bond and also undertake.
You won't tell in the appellate court, appellate last procedure of final hearing. It is goes 39, page 39 goes subject to. If cause of action survive, again you approach, now you withdraw it after the appeal is disposed of.
We can at least say that now you see 25/4/2025, that hearing has not taken place.
Not taken.
So we can, that because the it appears that land council so and so filed Sajira, land council appellant postal so and so. No step has been taken. They are found to be absent on leave, hence judgment expert no, but on final hearing we can direct for expedite weapon.
That's it.
The land council for the petitioners file an additional affidavit with the copy of the order sheet of RFA number 19 of 2024 passed by the District Judge Jharsuguda. The affidavit along with the order sheet is taken on record. The petitioner has challenged the letter number 180 dated 21/8/2024 of the general manager Eve Valley area, opposite party number 2, wherein it has been held as follows. Your disposal of representation at annexure 3. So it would have scenes to achieve page number 39, scenes to RFA number 19 of 2025. A পর্যন্তটা quote করছেন. Page 39. Since from the order sheet placed by the land council for the petitioners before us, it appears that the hearing was supposed to be held, hearing of the appeal was supposed to be held on 25/4/2025, and according to the land council for the petitioners, the same could not take place. We directly District Judge Jharsuguda to expedite the hearing of the RFA number 19 of 2024 and pronounce the judgment preferably within 3 months from the date of reopening of the court after ensuing summer vacation. The parties shall cooperate with the Reliance District Judge for Jharsuguda for hearing of the appeal. Accordingly, the writ petition is disposed of. Yeah.
Item number 5 is amendment petition ତଳେ ସେ consolidate ଦେଇଛନ୍ତି ଦେଖି item 5
ନାହିଁ
ନାଇଁ ମୁଁ କହିଲି ଆମକୁ କପିଟା ଦେଇଛନ୍ତି
ଆଚ୍ଛା ସେଟା ଯୋଉ ଷ୍ଟେଟ କୁ କପିଟା କାଟିଦେବେ ବଟ୍ ରେଜିଷ୍ଟ୍ରି ଟୁ କେସ୍ ଦ୍ୟାଟ୍
along with the IA, the consolidated rate application has been filed.
ସ୍କାନିଂ ରେ ନାହିଁ ବୋଲି କହୁଛି ସେଇଥିପାଇଁ କହୁଛି ସେଟା ପ୍ଲେସ୍ ହବା ପାଇଁ ଷ୍ଟେଟ କୁ ଦେଇଛନ୍ତି ସେ ପୋର୍ସନ ଟା ଆପଣ କହିଲାଠୁ ସେଟା କଟା ହେଇଗଲା କିନ୍ତୁ କୋର୍ଟ ପାଖରେ ସେଟା ନାହିଁ
ଅଛି ଆଜ୍ଞା
ଆସିନି ଏଠିକି ଆସିନି ଏଠି
ଏଇଠି ଆସିନି ସ୍କାନ ହେଇପାରୁନି
ନେକ୍ସଟ
yes
Item 7.
Yes, item 7. Mr. Sukant Kumar Naik. Pass over for him, sir.
last time भी non appealsଥିଲା
The prayer is,
एगार चार दियर
just see the prayer, what kind of prayer.
None of you are from repeated corruption. Don't clear that.
settlement लिंगराज महाप्रभु को नारी चाहिए cancel
Date 9 कितने?
Was the order there falls then of grant was a
Which order? Ceremony order. Except 3.
up to correct ROR in Skritivan status in favor of Lingaraj Mahaprabhu Vijay Bhubaneswar.
to prayer petition issue nature mandalo in the secretary to pass the order in OA case number such and such
ଜମିଟା ବର୍ତ୍ତମାନ ପୁଣି ଲିଙ୍ଗରାଜ
ଲିଙ୍ଗରାଜ ମହାପ୍ରଭୁ
ହେଇଗଲା
ପଳେଇଲା।
ନା ତାଙ୍କର ଇଏରେ ସେଟା ବୋଧେ ଥିଲା ଆଚ୍ଛା ଆଜିର ପବ୍ଲିକ ଅବଜେକ୍ସନ ଇଏ କଲା ଆଚ୍ଛା ରିପୋର୍ଟ ଅଫ ଦି RI ରେ ଇନିସିଏଟ ହେଲା ବେ ବନ୍ଦୋବସ୍ତ ଲ୍ୟାଣ୍ଡ ତା ନାଁ ରହିଯାଇଥିଲା ନବକିଶୋର ବଡୁ ନାଁରେ ତାପରେ occupier is so and so notice issue ହେଲା notice to the public objections so and so
page 27
But who is he?
yeah that is his location
ଏଇ ଯୋଉ ଲୋକଟା କି ଯାହା ନାଁରେ ପ୍ରଥମେ ରେକର୍ଡ ହେଇଯାଇଥିଲା ନବକିଶୋର ବଡୁ
संजय कुमार महाप्रभु
ନବକିଶୋର ବଡୁ ହଉଛି ଜଣ ତାର ଗ୍ରିଭାନ୍ସ ଥିବ କାରଣ ତାର ଇଏ କଟିକିନି ଲିଙ୍ଗରାଜ ମହାପ୍ରଭୁଙ୍କ ନାଁରେ ହେଲା ଇଏ କିଏ ସାର୍ ବିକିବାକି ଦେଇଥିଲା କି ସେ ଯୋଉ
Navakishore Bodu sold it to him. Para 4 of the writ petition.
ଆଚ୍ଛା
They said opposite party number 2
yes,
due
Pacha.
to the legal necessity sold the land to the petitioner.
ହୁଁ
2017.
ଗତ ଥର ବି ରିପିଟେଡ କଲରେ ନଥିଲେ ଆଜି ବି ନାହାନ୍ତି କଣ କରିବି ଆଉ ଗୋଟେ ଦବା non appears for the petitioner. It appears that on 11/4/2025 when the matter was taken off nobody appeared on repeated call put up this matter on 24th of June 2025.
Item 8.
Oh, the senior advocate appear in this case. So
For the
here we-
petitioner,
My lord.
yes.
Here
What
we
do you
had-
want?
Adjourn.
No, adjournment,
My lord.
Here they are challenging the arbitration order.
arbitration order.
Order passed by the NHA arbitrator.
Yes, you are to go in appeal, 34 appeal provision achi.
Adjourn.
Appearance memo of Mr. Ashok Hon'Ble and senior advocate is filed today, which is taken on record. And counsel for the petitioner, 6 for an adjournment. In this petition, the petitioner Messrs. MP Enterprises has challenged the order dated 15 to 2025 passed in Arbitration case number 2 of 2024 issued by memo number 57 dated 6/3/2025 by the collector from arbitrator, NH215, Kingsure under annexure 6. देखिए NH Act है देखिए. Section 3H5 and 3H6 of the National Highways Act 1956 are quoted herein below. Since against the impugned order, there is appeal provision in the Arbitration and Conciliation Act 1996, the Learned Counsel for the petitioner shall apprise this court as to why, in spite of availability of the alternative remedy, this writ petition will be entertained. Put up this matter after ensuing summer vacation. Yes.
Item 9.
May I please, madam? So by filing this petition, the petition has challenged the order dated 17 March 2025.
What is the IA was allowed for?
My lord, I have allowed and I have already filed that corrected page, my lord. So
Page number 12.
Ma'am.
Okay. What is the prayer in this?
I have challenged the order of dismissal dated 17th March 2025 passed by the Law Tribunal, CAT Contempt Court in OR number 343.
That order is annexure 14.
14, my lord. Para 6 is the operative portion of that order, my lord.
Para 6, page number
75, my lord.
75.
My lord, instead of posting minus of previous, this is time, my lord, I can place last 7 lines of page 75, my lord.
What was your prayer before the?
My lord, my prayer, I have challenged the order of rejection by which the third financial operation claimed by the petitioner rejected on the ground that I have got 1 regular promotion and 2 final operations, my lord. So, my lord, my case was before Law Tribunal.
You have filed the original application here.
Before Law Tribunal.
We copy counter affidavit ये सब फाइल कर जंती याद है ये जो annexure.
I have filed all annexures, my lord.
Counsel,
Counter file, rejoinder also I have filed.
when the order has been passed and you are challenging the order, what grounds you have taken in the OA? What is the counter affidavit?
I have filed the counter, my lord. I have filed the
What
rejoinder.
is the annexures? First, show us the original application copy. Why have you not filed the original application copy as the annexure? It's certiorari proceeding, so you cannot develop it like that. So that is why it is very necessary to see what stand was taken.
Copy of OA filed? No.
No, that is
I
not
copy
been
with
filed.
me, but I have filed all
File
annexures.
it. We'll take up this matter next.
May I, my lord, only Lord Tribunal has set out a third case and dismissed my.
How can we know? That is exactly what we want to say, that what was your case before the tribunal? What is the counter affidavit? And if you say that the tribunal has made out a third case, for that, the perusal of the original application is very much necessary, and that you have not filed.
Only one sentence can clarify my lord's mind.
Please file it. We'll
No
take up
problem,
this
sir.
matter next week. The learned counsel for the petitioner seeks for an adjournment till next week to file the copy of the original application, which was filed before the Learned Central Administrative Tribunal, on the basis of which OA number 260/00343 of 2020 was registered. List this matter.
I can file tomorrow.
Put up this matter on 13th of May 2025. Yes.
My appearance depends.
ठीक है your Mr. What is your good name?
Darpanarayan Patnaik.
Darpanarayan Patnaik. You are the senior
Senior
panel
panel counsel.
Senior panel counsel for Union of India is present. Hello? Yes.
Okay.
Item 10.
In this case, the annexure 2 is pending by law. My name is not reflected in the ROR for which I have filed this representation to be considered while reading it.
No. If in the ROR your name has not been mentioned, then how the compensation will be paid to you by the LAO for
I
which
am
you
the
are
legal
filing
heir of the
representation?
Ujjali Kumari, dead person. My name, my mother's name.
ସେମାନେ କାହାକୁ ଦେବେ compensation? ଯାହା ନାଁରେ ROR ରେ ଜମି ଯାହା ନାଁରେ ଥିବ ନା ଆପଣ ଥାର୍ଡ ପର୍ସନ କୁ ଦେଇଦେବେ? ଯଦି ଆପଣ କହୁଛନ୍ତି ଯେ
ମଦର ଡେଡ୍ ହେଇଯାଇଛି,
ଠିକ ଅଛି, ତାହେଲେ ଆପଣ ଲିଗାଲ ଏୟାର ସାର୍ଟିଫିକେଟ ଆଣିବେ, ଆଣିକିନି ଆପଣ ତାକୁ ସେ ROR କୁ କରେକ୍ସନ କରିବା ପାଇଁ ଆପଣଙ୍କର ନାଁ ସବୁ ଦେବେ, ତାପରେ ଆପଣ ଇଏ ରିପ୍ରେଜେଣ୍ଟେସନ ସିଏ କଣ କରିବ?
representation my case,
There is a due process of law to be followed. Not that every due process of law is cut short by a representation.
When I will represent only to
You follow the due process. What this representation?
ଆପଣ ଲେଖିଦେଲେ ସେ ଜମିଟା ମୋ ମା ନାଁ ରହୁଛି, ମୋ ମା ମରିଗଲାଣି, ସେ ଜମିଟା ବର୍ତ୍ତମାନ ମୁଁ ପାଇବା କଥା, ତେଣୁ ଯଦିଓ ROR ରେ ମୋ ନାହିଁ ସେଟା ମତେ ଦିଆଯାଉ, ତେଣୁ ଏମିତି ଲେଖିଦେଇ ଚାଲିଗଲେ ସେଗୁଡାକ କେମିତି ସେଗୁଡାକ ଦେଖିବ? unless
I will provide the
no
necessary document, I will provide. That may be observation.
You see, so many things are necessary. If your mother is dead, first death certificate is necessary. Who are the legal heirs of your mother? That is also necessary. So that can be if you not either that ROR needs to be corrected because other, and you will file just a there is only one legal heir.
Only legal.
How can it be known? You have not even filed the legal heir copy here in this petition. Neither the death certificate nor the legal heir certificate has been filed in this petition. How you will direct that the compensation amount will be paid to you if the land stands recorded in the name of your mother?
I have applied for.
Applied for କରିଛନ୍ତି ଆପଣ ସବୁ ଡକୁମେଣ୍ଟ ଧରିବେ ଏକାଥରେ ଆପ୍ଲାଏ କରିବେ। ଆପଣ ଆଣିବେ ଗୋଟେ representation.
We are creating a parallel jurisdiction in the representation.
Death certificate.
These are disputed questions of fact to be decided by some authority, not by a representation.
Not representation.
You see many cases where this representation order has been disposed of. ସେମାନେ God knows ଲେଖି ଦଉଛନ୍ତି High Court କହିଛନ୍ତି ପେମେଣ୍ଟ କରିବ, ପେମେଣ୍ଟ କରିଦଉଛନ୍ତି, ତାପରେ ଅନ୍ୟ ଲିଗାଲ ଏୟାର୍ସ ମାନେ ଆସିକି ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି ଯେ ଆଜ୍ଞା ଆମେ ହଉଛୁ ତାର ଲିଗାଲ ଏୟାର୍ସ, ଆମକୁ ଏଠି ରିଟ୍ ପିଟିସନରେ ପକ୍ଷ କରାଗଲାନି, ସେଠି ବି କିଛି କଲାନି, ଆପଣ ଗୋଟେ ରିପ୍ରେଜେଣ୍ଟେସନ ଡିସ୍ପୋଜ ଅଫ୍ କରିବାକୁ ଡାଇରେକ୍ସନ ଦେଇଦେଲେ, ସେ ବେଳେ ହାଇକୋର୍ଟ ଅର୍ଡର କରିଛନ୍ତି ତମେ ଦେଇଦିଅ, ବଟ୍ ହାଇକୋର୍ଟ has never said that the amount is to be paid to the petitioner. So that is the problem.
This is a scandal now.
So that should not be allowed.
Allowed to file those documents.
You resort to remedy available to you under law.
And directly,
The petition has been filed with a for a direction to the opposite party number 2 to pay half share of the ex gratia compensation amount to the petitioner for the acquired land under Annexure 1, the Land and Counsel for the petitioner submits that a representation has been filed before the Land Acquisition Officer Sundargarh, opposite party number 2 on 17/2/2025, and the same may be directed to be disposed of by the opposite party number 2. We find that the land has been recorded in the name of number of persons, and the case of the petitioner is that the mother of the petitioner, who is now dead, is the one of the recorded tenant. However, in this writ petition, the other persons in whose name the ROR has been recorded are not parties. Death certificate has not been filed. Legal heir certificate of the deceased mother has not been filed. Therefore, in view of the aforesaid infirmities, if we direct the opposite party number 2 to consider the representation, that will not serve any fruitful purpose. The petitioner is at liberty to take appropriate remedy in accordance with law to claim the benefits as mentioned in the prior portion of the writ petition. Accordingly, the writ petition is disposed of. Yes.
Item 11.
The NSA has acquired the land of the petitioner. Being aggrieved by the compensation, petitioners prefer arbitration case under section 3G5 of the NH Act, read with RFCT LRI. And the Honorable Land and Arbitrator pleased to pass an order on 28/8/19. On 28 as per the High Annexure 2. And
You want National Highways Act?
again,
Arbitrator order अकेले केबे
28/8/19.
तापरे कौन कले अपन चुपी बसियोले
No, sir.
आओ
Again and again, I visited to office, no answer has been coming out.
अरे order टा पर हेलानी अपन communicate ही दियो ना
That's किछि सुननाइ.
से ये order टा पुनी पाइले कोडू
I have obtained from office of the arbitrator.
तो आ against appeal अछि ना तो appeal को न जाए हाई कोर्ट कौन पड़े इसपे
Kindly turn to last page. I am
See, he
my
wants that
specific
it should be
prayer-
implemented. His prayer is this arbitrator award is to be implemented by this. court.
implemented. A direction
What is
to the-
the
Your lordship may see the prayer.
agree?
just to
Summons to the
clear
petition as per the order dated by land adjudicator arbitration. He wants the implementation of the arbitration.
So we are the executing court or what?
Yes, there is no specific amount here. The kindly turn to running page 15 towards last part. My specific prayer was that I am entitled for solatium since the payment has been made after 1/1/15.
That has not been given to you.
No.
So you have to challenge it. That is exactly what we say, that
So far,
if you are dissatisfied with the order of the arbitrator, there is a provision for appeal under the Arbitration and Conciliation
there is
Act.
no amount specified, so how to tell? Only to calculate as per the RFCP LRI.
What is the operative portion of that award?
Running page 15, last but one part.
Yes.
In the case in hand, it is clear that the date of award passed by the Kala in Mauja Palasa on 22/2015, which attracts the Government of India Instrumentation Supra. In view of the FOF and the law provision, the Special Land Action Officer in the Competent Authority NH 5 Korda is directed to recalculate the amount of compensation due to the petitioner in the new act, differential amount, if any, within 6 weeks.
So that is to be done by that a particular authority, Special Land Acquisition Officer.
Yes.
So what is your stand? That has not been done.
Only 30% as per High Annex of 1. Kindly see 30% solatium has been given. High Annex of 1 at page 10. 30% solatium has been awarded.
After this order was passed, whether there has been any recalculation.
No, they have not made till
So-
now.
So
They have
If
not
they will recalculate it and you find some flaws in it, then you are to seek appropriate remedy.
They have not been calculated or in
One minute.
Hmm.
Can I go? Many of them, the parties has visited the office.
So you say that that has not been recalculated.
No.
But you say that I'm not satisfied because the recalculation whatever is made, that will not be correct. That means you are to go there or you find the section and the Resettlement and
Kindly turn to running page 11. It is face of record, they have awarded me 30%. In case of 100%, because date of award is after 1150. This estimate itself wrong.
The arbitrator has now stated that it is to be recalculated. And if you say that recalculation has not been made, then it is to be made and you have to file representation or you challenge that order before the appellate office.
Provides a conditional procedure, followed in that way.
Basically, here is not challenged.
But may kindly see section 33. I think under section 33, the arbitrator himself, an application can be moved. Actually, just see, I'm not done this. Arbitration conciliation after that.
No, it says that.
If that. But in the National Highway Act, section 3A 5G says the Arbitration Conciliation Act will apply in full force.
Yes.
Once there is a difficulty with regard to interpretation, then I think the application has to move before this arbitration. And section 33, Lakshmi kindly see. I think that is the remedy. Malan? Yes, so section 33 is there, so I'm saying, Malan. And 37 is appeal, 34 is challenge of the award before the commercial court.
I'm just.
He needs calculation, Malan.
I need to.
That is.
He needs implementation.
Well, if he needs implementation, section 36 for that.
He needs implementation of that order.
Then 36.
Prayer the but that has not been prayed for here. Prayer is not there. He has to challenge.
For the implementation.
Direction to acted upon the order of the.
Yes. Now he has submitted direction to implement that direction to work out the order dictate.
If you are not satisfied with the award and the grievance against the parties complaint. For both the purposes, the remedy is provided as
Not the land council for the petition and council for the state. This petition has been filed by petitioner Mishra for a direction to the opposite party, number one. Land acquisition officer and competent authority and 16. For recalculation and disbursement of the compensation with the petitioner to be order dated 28/8/2019 asked by the grand arbitrator passing ARB case number 24/2016. So the prayer has been made on the state but the grand council for the state of subject that the arbitrators award is not correct and therefore he wants to challenge the same. So needless to say that there are alternative remedy available for the arbitration position to challenge the order passed by the director and district magistrate arbitrator further in arbitration case number of problem to go through the petition of proceed allocate the as well of the
So delay may be called. Delay in filing. 3 months. There is a limitation of strictly 30 plus 3 months and 30 days in 30,000.
Item 12.
Transposition. Renumbered is. The Lordship may see the audit 65/2000.
And transport is for and registered cars of PC bracket plate number 75/2018 has become infectious and his function is going same stock. In view of that will be disposed of. You don't know which of disposed there.
ଏଇଟା ଗୋଟେ ବ୍ୟାଚ୍ ଫାଇଲ୍ ହେଇଥିଲା ସେ ବ୍ୟାଚ୍ ର ସମସ୍ତେ ୱିଡ୍ର କରିନେଇଥିଲେ ପିଟିସନର କେବଳ ଏକଲା ଥିଲା।
WBC number, WBC bracket number 75 of 2018. Dismissed to
or long prosecution, therefore, there is no need to pass any further order in that WPC. Since we have in this petition, which is only to or require of the aforesaid petition, this petition that is the land council for the does not want to raise this petition according to the petition is crucial. That's not the question. Say the
Attendance. Oblige.
Item 14.
Mine. The similar issue decided by your lordship in another case, the petitioner's mother was declared as a beneficiary to receive the compensation as per order of the LA Collector Balangir. So before payment is made, she expired. So another case, the lordship has transferred the local adalat having some observation. Same impugned order is same. Payment hitla part payment, it's a payment hini before payment died. Petitioner's mother died. So it is my house order lordship's observation. My lord, the amount, the and improved order 24. Annexure 10, page 32. So, my lord, the paragraph number 5, the petitioners have submitted that their mother Linga Dharwa was listed at serial number 77 of the affected and displaced family of village Khutpalli under Resettlement and Recalculation for 2006. On dated 12/2/2020, their mother died and the compensation amounting 8,69,000 had not been paid to her. The petitioner's claim is that being the legal heirs and successors of deceased Linga Dharwa, they are entitled to get the compensation as the legal heirs and successors. The project director R&R LSIP Balangir stated that rehabilitation and resettlement assistance to two families, namely Ananda Dharwa and Linga Dharwa, deceased mother petitioner of village Kutpalli, as per RR Police 2006, under Lower Suktil Irrigation Project, Balangir had been sanctioned and communicated to their office order by so dated 18/11/2021 of the director, Rehabilitation Resettlement cum Secretary to Government, DOWR, Odisha, Bhubaneswar. On sanction of RR's assistance, without making a delay and after completion of the public objection period, the payment was made to the petition number 1, Ananda Dharwa, on 27/12/2021. In the sanction order, next para, my lord, the director RR clearly instructed to make payment to the affected families only after verification of supporting documents in order to ascertain the authority of the beneficiaries. Yes, right. Basically, the petitioner Ananda Dharwa submitted that his mother Linga Dharwa died on 12/2/2020 before the rehabilitation assistance amount got sanctioned. So it was sanctioned 2021. As rehabilitation assistance was sanctioned wrongfully in favor of the dead person Linga Dharwa, it is liable for rejection. The rehabilitation assistance was given to the eligible person of Khata number 111, a village Kutpalli, such as Anand Dharwa, a separate family, as per the definition of family, section 2F, Odisha Rehabilitation Policy.
In that case, what would happen is part of the payment was made and remaining part payment was not made. So therefore, you say that the part of the payment made to my mother.
Yes.
Family. Separate family. And the rest of the part in the above activity. Before the sanction was made.
My sanction was made. Yes, ma'am. Yes, ma'am. No, ma'am. Thanks, ma'am. No, ma'am. In the beneficiary list, annexure 4, page 22. List of the.
Other thing was there. Before the sanction was made, the other child.
My lord, thing is that it was after the selection list prepared by the LA collector, revenue inspector, the page 21, in the year 2000, it was. Well, I think a little bit. See, because let's be right. Part, let's be right.
This case complementary legislation.
Yes, my lord, yes.
The five or on seven passed by the collector of that. Based on order the party Director Palangi and Special Land Acquisition Officer, Rural Circle Litigation Project Palangi is to reduce the sanction amount of 8 lakhs of the state in favor of the petitioner. We did stipulated that since their mother's name of Christmas, each of the beneficiaries of this business of Hunter and serial number 77 in the acquisition and obstruction of birth. The Federal Council petition as annexed the this issued by the government of Odisha and by the the proof is that the name of the order was right this serial number 77. Is also filed yesterday of the mother and legal certificate of the mother to show that all the petitioners are the legal heirs. from the input order, organization deal, it appears that, that on year two, 2020, the father of the petitioner died. And, the of the petitioner, that the compensation amount is 8,69,000 has not been paid to power. But the director found that the rehabilitation assistance was sanctioned wrongfully in favor of a third person, that is the father of the petitioner. And therefore it was liable for rejection. And the rehabilitation assistance was given to a reasonable person. That one 40 days, such as unknown loss, bracket case of petitioner as a separate family, as per the definition of family in section 2F of the Orissa Rehabilitation Act, except 6 stop the land council for the petition service that since the figures of the deceased mother petitioners are entitled for the compensation amount which has not been paid, the order passed by the collector Palangi, Ramesh taken, he is not sustainable. I of focusing on some question of mission, GTS, school for and council for the state as such office on behalf of all the authorities.
Yes, ma'am.
Item 15.
15 and 16 but there is another 5 to 6 methods are there. Giving the amount can taken up next week, along with this, these two, 5, 15 and 16.
Item 17.
In this case, the arbitrator hour on the challenge. Item 17. On behalf of Mr. Raut, kindly adjourn next week.
You are not an associate of Mr. Rao. You are associate with the Rao. The arbitrators award has been challenged here. So there is a provision in the Arbitration Conciliation Act to challenge that such award. Alternative remedies are available.
Yesterday, your lordship, several matter solutions will say thank you, say out the
Same matter.
It's a number.
8 and 9.
but the list of the
Lots.
And not we take power pass which was stated. So you can do their portion which is the case number will come back.
My lord, my appearance on behalf of
These are item number 70.
22, 23. 22, 23.
Well, 21 I am appearing this way. Am I appearing this way?
20.
My lord.
20. 2021. Item 18. Item 19.
Mayor PGL also. I'm in VC Melo. My lord, the petitioner is an ex-serviceman. In the year 1990, he made an application for allotment of a land which was dropped because by then he was in service. Then again he made an application in the year he has made an application on 24/7/2013, that is after his retirement. That application was OP number 3. The collector has directed the Tahsildar to cause an inquiry into the matter. Basing on the direction of the collector, an inquiry was conducted by the Tahsildar Khajuripada, and the Tahsildar Khajuripada was of the view that in view of the latest notification of the government of Orissa, in the Gazette notification number 7390 dated 19th February 2014, no land can be allotted, instead monetary benefit, and accordingly he submitted the report on 19/10/2024 before the collector. As of now, no decision has been taken by the collector. The Annexure 7, your lordship may kindly see the report of the Tahsildar. Annexure 7, page 19. So, if I'm not entitled by way of that notification any land allotment, but instead that monetary benefit will be given.
The collector has to take a decision.
Yes, ma'am. Yes, ma'am.
This is of the report submitted by the Tahsildar.
Yes, ma'am. Yes, ma'am.
That is your limited view.
So as of now, the collector has not taken any decision. Although in his letter in October, he has said that most urgent, but as of now, he has not taken any decision.
earlier, as per the lease case number 154/90.
That was dropped because I was by then in service.
Second service second file collector record matter Tahsildar. Tahsildar report
That is monetary against that monetary.
সেই রিপোর্টটা সাবমিট করেন 19/10/2024 তার উপরে পর্যন্ত ডিসিশন কালেকশন
to take instrument.
This petition has been filed by petitioner. So they for a direction the opposite parties for giving the monetary benefits that include the inquiry report submitted by the Tahsildar under the financial
7.
The land council or the petitioner submitted, right? So that is the article. the petitioner was an army personnel and has been retired in the rank of flight from the Indian Army on 1/5/2006, and he made an application.
And my lord, the district signing, state signing board has given a certificate that is annexure 1 also.
He made an application before the Tahsildar, Patuliyapura, which is party number 24/7/2015 for allotment of a piece of government land. And the said application was disposed of on 19 February 2014. And further appears that the petitioner submitted another application like it is
Yeah, annexure 2 2013 ने दिली.
another application on 24/7/2013.
आगे तापर कलेक्टर annexure 3 रे डायरेक्शन देले to cause an inquiry. Annexure page 14.
Party number 5, and the collector
Annexure 3 page 14.
The assistant collector revenue collectorate from Umar Party directed the Tahsildar Patuliyapura to hold an inquiry on the petition filed by the petitioner. And after conducting the inquiry, the Tahsildar has submitted a report under letter number 3050/1910 by annexure 7, wherein it is stated as follows. Reference to the land council for the petitioner submits that in view of such failure of the Tahsildar Patuliyapura and the gazette notification of the government of Orissa dated 19 February 2014, the petitioner is entitled to monetary benefits as per the notification. But in spite of receipt of such letter, no monetary compensation has been disbursed in favor of the petition, and therefore submits that the opposite party number
3
maybe 3 or no 4.
My lord, 3, the collector is opinion number 3.
Assistant collector 43, assistant
My collector has a decision nebe. Assistant collector has communicated the direction.
We had to take a decision on annexure 7, pattern RBS, Reliance Council for Support, Reliance Council for Recalculation. There is no objection to such submission. Any changes of the laws, they to dispose of the petition directly the opposite parties number
3 and 4 to take a decision on annexure 7, preferably within a period of 3 months from the date of production of the certified copy of the order by the petitioner. It is made clear that we have not expressed any opinion on the merits of the case or entitlement of the petitioner for the monetary benefit accordingly the writ petition is disposed of. Yes.
Yes.
That took care of it. You're just coming. calling.
Item 24.
What is this matter?
The petitioner has prayed for enhancement of the compensation amount of the land acquisition. Yes, my lord. In this regard, they filed a representation of unless a file.
64 provision you
Yes.
have not resorted to.
Yes, I have the
64 of the 2013 Act. It says that if you are not satisfied, then you can file application so that it would be referred to the authority. Have you not taken recourse to that?
No, I have given the representation before the collector. Under annex of file.
Representation na कौन होगा?
No, I'll ask.
देखिए because in that application you are to satisfy
My
that how the you are entitled to get more amount. Huh? So any person interested who has not accepted the award may by written application to the collector require that the matter be referred by the collector for the determination of the authorities.
my
And that would be amount of compensation, the person to whom it is payable, all these things.
yes,
So representation में कौन होगा?
I'll ask. I was already giving the objection.
The learned counsel for the the petitioner has filed petitioners have filed this writ petition with a prayer with following prayers कर दूं एक दो तीन टा quote कर दूं. The learned counsel for the petitioner submitted that the petitioner has submitted a representation before the collector from District Magistrate Sundargarh, opposite party number 1. Wherein it is indicated that the amount of compensation has not been properly calculated. And he has also prayed for making a reference to the appropriate authority under section 64 of 2039. However, the learned counsel for the petitioner submitted that the petitioners may be permitted to withdraw this writ petition to file a appropriate application before the opposite party number 1 in terms of section 64 for referring the matter to the authority, giving all the detailed particulars. Full stop. In view of such submission, the writ petition is disposed of, giving liberty to the petitioner to file appropriate application before the collector for making reference to the authority for enhancement of the amount of compensation. Accordingly, writ petition is disposed of. If the particulars that how you are entitled to by filing a representation, you will not do. This amount adjacent area, a land ro valuation ସବୁ ଏଇଆ ହଉଛି ଆପଣ ଏତିକି determine କରିଛନ୍ତି ତାର details ଦେଲେ
ସେଠି ମୁଁ mention କରିଛି ଯେ representation to ସେଠି
that should be in a proper way.
Next
Yeah.
also same.
Next one. That's good.
Yes.
Item 26.
25 same. 26.
That goods.
Yes, Mr. Mahanti.
My lord, the opted land on which the petition house is situated has been acquired by the, has been decided to be acquired, my lord, by the Southeastern Railway for the railway line from Amarda Road to Subarnarekha Port. You lordship can see plot number 17 under the annexure I have given the ROR. 1722 plot number 10 dispute starts recording in the name of the petitioner and his brother. It was divided 5 decimal, 5 decimal.
No, notification has come that they are
Notification has
intending
come.
to
Yes,
acquire the land.
Land, here annexure 3, my lord.
Annexure 3.
3.
So,
They want to acquire 3 decimals, my lord.
no.
My
ଆପଣଙ୍କ ଜମିନ୍ ରିଫ୍ଲେକ୍ଟ ହେଇଛି?
ହଁ ସେଟା 3
ଏତ ଦ୍ୱାରା ଆପଣଙ୍କୁ ଜଣେଇ ଦିଆଯାଉଛି ଓକେ
ସେମାନେ ବନ୍ଧ
ସ୍ଥିରକୃତ ହେଇଛି ରେଷ୍ଟ୍ରି କରିବାର ଏକ ବୈଠକରେ ଆପଣ କଣ ହେଲା ତାପରେ?
Then my lord, they acquired that this land 10 decimal divided into 2. Half portion I have constructed my building and another half portion my brother has constructed building.
Yes.
It is in the southern portion my land is there, my lord. That land they want to acquire 3 decimals land. I have out of 5 decimals, 3 decimals will go and only 2 decimals will left out. My house is 1,000 square feet. Therefore, I challenge that acquisition before this honor court. I made a representation that if you want to acquire the entire my 5 decimals land. Because if you acquire 3 decimals land, a portion of my house will be demolished and it is not possible at all to stay in that house.
Right.
That this honor court directed that to dispose of my representation by order dated 27 to 2024.
That is annexure 5.
Annexure 5, my lord.
Then what happened?
Then now they have that was measured. Your office can come to annexure 6. That the collector has said while the operative portion at page 30.
30.
Well, before 29 at least. The
29.
Land, 29 last para. The land acquisition officer Baleshwar has said that as per the administrative approval of
29 পর্যন্ত
29 the last para.
Last paragraph to start is period the petition.
After the 30
last.
LO Baleshwar. 29. The LO Baleshwar has said that as per the administrative approval of comments and commerce sector, that is commerce and transport department, the requisition authority, that is director ports and IWT, Orissa Bhubaneswar has submitted all documents as per the so for approval of the estimate for direct purchase of private land in village Sansadabad for railway corridor to Subarnarekha Port to Jomuk. According to the DLCAC meeting was convened and Collector Baleshwar approved the estimate. In view of the above, considering the repetition of the petition at Annexure 4, the Tahsildar Botta was requested to demarcate the said land and submit detailed report. Accordingly, Tahsildar Botta submitted the report by letter no. 4392 dated 4/12/2024. The Tahsildar has intimated that the suit land, that is plot no. 1722 of Mauja Sansadabad, has been demarcated by the revenue staff and found that the constructed house of the petition is at a distance of approximately 12 feet from land to be acquired, my lord. That is not possible at all. Why? 12 feet away. 12 feet, my lord, total 5 decimals. Out of 5 decimals, I have constructed 1,000 square feet house.
Where is the map? Can you show the map?
Map I have.
All these things, the
Map I have given, my lord. You will also kindly see annexed to my house, my lord.
How can it be? Now in a writ petition, all these things will decide.
My lord, my prayer.
See, the Tahsildar has gone to the place, visited the place, gave a report. How can we doubt in the writ?
My lord, this is 5 decimal land, it is on 1,000 square feet house is situated on that land, my lord. My lord, only 2 decimal left out. 2 decimal is less than, my lord, 800 square feet.
It's all right, but these are the things.
My prayer, my lord, either if they want to acquire this as per the report, let them acquire the 12 feet. I will have no objection, my lord. And if they demolish my house, let entire land be taken.
Suppose it is your case that they want, let us say, a particular portion. And it is your case that if that particular portion is taken away, in the balance portion, that my
House should be
demolished and it would not be possible to live in that place. So
Yes.
these are all again disputed thing. How can repetition will adjudicate?
And the Tahsildar went and saw and says that it is 12 feet away from the land to be acquired.
Yes,
You
I
will
will
have
have no
12 feet away.
I will have no objection. If from 12 feet my house,
That is the report.
that is the
ଆପଣଙ୍କର ଯୋଉଠି ଘରଟା ଅଛି
yes,
ସେମାନେ ଯୋଉଠୁ ଜମି ଇଏ କରୁଛନ୍ତି ସେଠୁ 12 ଫୁଟ ଦୂରରେ ଆପଣଙ୍କ ଘର
then I have no objection at all, my lord. But
ଆପଣ କହୁଛନ୍ତି ନାଇଁ ସେ ଘରଟା ନେଇଗଲେ ମୋ ଘରଟା ବି ସେଠି ରହିପାରିବନି
ନାଇଁ ନାଇଁ 12 feet ଛାଡିଦେଲେ ମୋ ଘର ରହିପାରିବ କିଛି ମୋର
ସେଇଆ ହିଁ ତ କହୁଛନ୍ତି ଆପଣ how can we say the report is very clear that has been mentioned there.
But see this more କହିବା କଥା ହଉଛି
The Tahsil, again we are reading, the Tahsildar has intimated that the suit land, hala, plot number so and so has been demarcated by the revenue staff and found that the constructed house of the petitioner is at a distance of approximately 12 feet from the land to be acquired. So how you are telling that ସେଟା ତା ଭିତରେ ପଡି ଯାଉଛି ସେ ମୋର ଗୋଟେ portion ଟା ଭାଙ୍ଗି ଯିବ ଆଉ ବାକି portion ରେ
visualize my lord.
ଆଉ ତ ଏଇ ଜିନିଷ ଗୁଡାକ ଆମେ repetition ରେ କେମିତି adjudicate କରିବା?
5,000 that 5 decimals of land in my share. If I have constructed 1,000 square feet house, they acquired.
Where is the map? Can you show the map?
Map your lordship can come to map.
Where is the map?
Map I have annexed, my lord. At page 22.
22.
Towards the left side, my lord. You lordship.
କିଛି କରିହେବ one ଆପଣଙ୍କର କୋଉଟା ଥିଲା
1722 your lordship can map it. I have a map with it. ଆପଣ ପାଇବେ ତ
ଏଇଟା ତ ଘର ପଟଟା ଦେଇଛନ୍ତି
ଘର ଫଟୋ ନା ଏଇଠି ଦେଇଥିଲି
ଏଇଟା
yellow bottom.
Unless you go physically and see, it's very difficult to.
My your lordship can.
Now it is practically doubting the report of the Tahsildar without any basis.
My pair report lordship, your lordship confirm that let them acquire the land 12 feet away from the house. I will have no objection.
ଲେଖିଛନ୍ତି ସେମାନେ
ସେଇଟା ଲେଖିଲେ ବି ସେ ଭାଙ୍ଗିଲା ବେଳକୁ ଭାଙ୍ଗି ଦେଇ ପଳେଇ ମୁଁ ଭାଙ୍ଗି ଦେଲା ବେଳକୁ ମୁଁ ଅସୁବିଧା ମୋ ଘରେ ଯଦି ପଳେଇଯିବ ମୁଁ ରହିବି କୋଉଠି ଜୀବନ ଯାକର ସବୁ ଗୁଡା ମାନେ ଇଏ ନେଇ ଘର ଖଣ୍ଡେ କରିଛି ଯଦି ପଳେଇଯିବ ଘର ଖଣ୍ଡେ କୋଉଠି
ନାଇଁ ସେ ୟୁ ଆର୍ ରାଇଟ୍ ବଟ୍ ଏ ଟାଇପ୍ ର ଗୋଟେ ରିପୋର୍ଟ ଆସିଲା ତାପରେ ଗୋଟେ ନେଗେଟିଭ କିଛି ଜିନିଷ ହିଁ ନାହିଁ ଆପଣ ଖାଲି ଓନ୍ଲି assumption କରୁଛନ୍ତି
ମ୍ୟାପଟାରେ ଦେଖୁନାହାନ୍ତି more than 50% କେତେ ପରସେଣ୍ଟ ଚାଲି ଯାଉଛି ମ୍ୟାପରେ ଘରଟା southern portion ଟା let them respond my lord. If they will say that only 12 feet away from that, they will take my lord, I will have no. That house is my lord. Paragraph 15, my lord. Yes. That it is humbly submitted, there is no other essential house and opted land of the petitioner except the half share of plot number 1703 if only 3 decimals of is acquired from the share of the petitioner out of 5 decimals and a portion of the building is demolished. It will be very much difficult to stay in the said house and the petitioner cannot stay in the said house with his family members. Therefore,
totally contrary to what the report has been submitted.
Therefore, your lordship may call for responsibility.
You say that not the distance is not the
12 feet, my lord, I have given that.
If you question the report in that case.
I have report, my lord, the report is not with me. Report mate দেই না। My lord, I have taken, my lord, you will also kindly see para 12 re. It is humbly submitted that specifically the petitioner stated that after being separated from his brother opposite by 8, plot number 1722 was equally divided in between two brothers, and the southern portion was allotted to the share of the petition measuring an area of 5 decimals, and all the said land petition has already constructed a permanent residence building. If the 3 decimals land is acquired,
If 12 feet land is left out
yes.
from the building, the rest is required, it's no objection.
That the Vasta is to be acquired 12 feet from the building. If 12 feet land is left out from the building and the rest portion is acquired, the petitioner has no objection. Paragraph 12.
The petition has been filed by the petitioner, Sahoo Hon'Ble. Passing the notice of application of Sahoo Land council for the petition submits that there is no other residential house and estate land of the petitioner except half share of plot number 1722. If only it could soon 03 decimal is acquired on the share of the petition out of personal 05 decimal of the building is announced, it will be much difficult on the part of the petitioner to stay in the house. With his family members. And therefore, the opposite party should acquire the entire share of the soon 05 decimal of the petitioner in respect of plot number 1722. And their compensation and the additional system to be paid the petition. However, on perusal of the input notice, include order of the land collector and district magistrate RSO dated the 6 to 23,
6 to 26.
6 to 2025. And we find that the report of the Tahsildar was called for, and the Tahsildar has indicated that the full land, that is plot number 1722 of Moja,
Samsonabad,
has been demarcated by the revenue staff, and it has been found that the constructed of house of the petitioner is at a distance of approximately 12 feet from the land to be acquired. Therefore, the amendments taken in the petition that if the acres through 3 decimal of the land is the petitioner is acquired, then it would be difficult on the part of the petitioner to stay in the said house with the family members. However, the land council in the petition, the amendments have been taken that based on the report of the Tahsildar, the land is left out from the building and this portion is acquired, the petitioner has no objection. Since in view of the report furnished by the Tahsildar, it is apparent that the petitioner's house is at a distance of approximately 12 feet from the land of the land sought to be acquired for the railway project.
Railway project.
For the railway project, in absence of any other material, we are not inclined to enter into any kind of disputed question of fact, and it is expected that the by acquisition of the land, the opposite parties strict furnished by the Tahsildar, and there should not be any kind of damage to the constructed house of the petitioner, which is stated to be at a distance of approximately 12 feet from the land sought to be acquired. Accordingly, the requisition is disclosed.
But we are for the OP number 1 and 2, really. Yes. Sound টা আসু নাই, sound কম আসছে, শুভুনি।
Oh, sorry. We switched off.
Oh, sorry.
Oh, you have not heard this dictation, Mr.
No, we have had this dictation a little bit.
They are just to stick to it. The Tahsildar has reported that the acquired plot is at a distance of, so there would be no question of any damage. So don't damage the house structure, and you acquire the land which you
Out of 10 decimal, 3 decimal are there acquired and giving the compensation.
that is
That he doesn't have problem there.
that yes, next.
Item 27.
Right here. The petitioner wanted to have conversion of his offered land from leasehold to Sthitivan status. There is a provision under the Orissa Government Land Settlement Rule, Rule 5C1. And the Lordship will see page 59.
That conversion fees and consent fee are required to be paid.
Conversion fee, that is under the statute.
Yeah.
The consent fee is something which is unknown to statute. They are charging for the conversion.
Decision has been taken, and the purpose is that you can utilize it freely now.
No, right, but in fact, if the statute permits, if there is a provision statute, I'll abide by that. And for conversion, the consent fee is something, and Lordship will see the conversion charges are 32,000 lakhs, 35,000. The consent fee is 1 crore 13 lakhs 24,000.
Yes.
And the statute doesn't permit, Lordship may kindly see Rule 5.
When this decision was taken, this has been done
in 22, and thereafter when I represented to them, they come out with at Annexer 7, page 62 in 24th of February 2025. Lordship will see that at page 62, my lad.
Yes.
Lordship may kindly see first note page, that Annexer 4 at page 59.
Annexure 4.
Yes, at page 59.
What is that?
My lord, I am directed to invite a reference to your conversion application on the subject noted above, and to say that the government have been pleased to acquire permission for conversion of the leasehold plot number so and so in Suryanagar freehold. You have to deposit towards conversion fee rupees 32,35,000 and 538 and rupees 1 crore 13 lakhs only through online treasury deposit and to submit the copy of the challan to the department. Now, what was that 1 crore for? Not mentioned. Then I inquired from them. After inquiry, my lord, I came to know that they are charging a consent fee.
Consent fee.
Yes. And then what should be that consent fee is alien to my lord, the rules and the procedure.
Where is the lease?
My lord, lease at Annexure 1, that in initial lessee. And your lordship has put a very pertinent question. And your lordship will find in that lease at page 28.
Yes.
Well, at clause Roman 14.
Law, Roman?
Roman 14.
Yes.
This is in regard to Malad that if that he shall not without the consent in writing of the lessor use or permit the use of the said land for any purpose other than that for which it is leased or transfer the same without such consent. Well, this is all. And then Malad, I purchased from the original lessee. The same thing gets reflected in the transfer deed that lease conditions should remain intact. Thereafter, when I seek for conversion, then this consent, initially in the conversion letter, there was no mention about the consent fee. When I inquired that they are charging a conversion fee, then why the page 62, Malad, Annexure 7, page 62, then Malad refer to a particular government notification. Let me read you the entire letter.
Yeah.
In inviting a reference to the subject cited above, I am directed to say that you have filed one representation on 16/11/24 before this department requesting to consider and recalculation and reconsideration deposit of the consent fee at prevalent rate and also to waive off the consent fee amounting to 1 crore 13 lakhs and to allow the execution of so-and-so. Permission of the conversion of the leasehold so-and-so was accorded in your favor. Then let me kindly say next para. In this connection, it is important to indicate here that the government, after careful consideration, why did this department office number so-and-so have been pleased to clarify on the realization of the consent fee. Government, after careful consideration, have been pleased to order that in the event of non-realization of the consent fee from the lessee at the time of transfer of the leasehold plot, I want a conversion. Even transfer also they cannot because that will hit by section 10 of the Millard Transfer Property Act. And Lordship may kindly say at this juncture the rule.
No, just read it out. Don't go here and there. Complete it.
The transferee is liable to pay the consent fee as per the rate and benchmark valuation in force at the time of realization of the dues. In view of the above, your prayer to reconsider or recalculation and reconsideration of the deposit of the consent fee.
So this decision was taken. Have you challenged this decision?
This is what I am challenging now, Malad.
No. This government, they are challenging.
This is for the first time I am coming to know about this letter.
Have you challenged in the writ petition that the decision which has been taken 2018?
This Annexure 7 came to me whereafter I have challenged this in this year.
Right. Now, since you know that, you are to find out that entire that order and you can challenge it.
Now, will that particular communication? This is a communication. This is not law. As per Lordship may kindly see the rule, Malad, with regard to this. Can they?
Unless that particular decision of the government is challenged in the writ petition, coupled with what has been so on that basis they are passing. There should be a challenge to this, that this type of decision cannot be taken.
Now let me consider now this government letter with regard to transfer, not regarding the conversion. This is regarding transfer.
You place that entire what is that?
Government after.
No, we want to see that entire. It's not a piecemeal. It has been stated. Have you got the entire?
No, that I have not, Malad.
Place it. We'll take it on next week.
Malad, just see the rule, Malad.
No, just we will want to see that on what basis. There may be so many grounds might have been taken for justifying what they.
I am before Lordship because when they refused the conversion,
all right.
And the refusal of the conversion is on this, Malad.
Petition has been filed challenging the
And Lordship may just see annexer,
dated
brother, notification annexer 8 malad.
26/10/2020.
Lordship may just bear with me, brother. Annexer 8 is the notification.
Right, annexure 4. Annexure 4 and annexure 7. On perusal of
Lordship may just see annexer 8 malad.
just a minute. Annexure 7, it appears that the representation of the petitioner dated 16/11/2024 filed before the General Administration and Public Grievance Department was disposed of, and while disposing of the representation, the reliance has been placed on the department office order number 18611/CA dated 2/7/2018. The London Council for
That is annexer 8 malad. That is annexer 8 malad.
No, it is not stated there.
Well, it is there, malad. That particular letter 18611/CA dated 2/7/2018. It is at place 63, malad.
Yes. What is stated therein?
But in continuation to department order number so and so, government after careful consideration have been pleased to order that in the event of non-realization of the consent fee from the lessee at the time of transfer of leasehold plot by way of gift or sale, the transfer is liable to pay the consent fee.
Okay. And from the said order, it appears, which is at page annexure 8, it appears that it was in continuation of the department order number 5512/CA dated 27/4/2006. Will you produce it or will ask the state government to produce that?
Well, take what the unit is shown.
ଆପଣ produce କରନ୍ତୁ, we see the.
No, I would relevant, very much germane to issue.
All right.
Well, this is a notification of 2006 they are speaking of. But the amendment to this rule 5C that came into being, malad.
We will hear you on that. We just want to see entire thing. Let us.
Let them produce. It's a old lady, malad.
Let the Land and Council for the state produce the General Administration and Public Grievance Department order number 5512/CA dated 27/4/2006. Matter be listed on 13th. We are relisting it and you produce that later. Order number 13 May, yes.
And at the same time, you just address this, read the lease also, 2-2. Clause
Yes.
2-2. In the lease.
Clause 2-2, malad.
2-2.
Yes.
2 subclause 2.
Yes.
You must see that.
Yes. Absolutely.
Next.
Item 28.
Order dated in the service has not been complied manner.
Complaint report has been compliance report has been submitted by the Land and Council for the state, which is at flag A, and accordingly the contempt petition is disposed of.
Copy
You put a copy to the compliance report. Copy of the compliance report has also been furnished to the Land and Council for the petitioner. Accordingly, the contempt petition is disposed of. Eighter compliance report asini. Second asini. 29 edition. The Land and Council for the state submitted the compliance report today. So it is taken on record. The contempt petition is dropped. Next.
Receive 30. 38. 30.
Dispose of তিনটা প্রথমটা ଅଛି অলরেডি ফাইল করে এই দুইটা আজই ফাইল করে তাহলে আই সিরিয়াল না এই যে দিয়ে দিয়েছেন না কোটা 29 নো কোটা 30 র ଦେଇଛନ୍ତି
কেস নাম্বার অনুসারে
Contempt.
Next set.
List item number one.
Item number one, my lord, I am not virtual mode.
Appellant inside custody was only.
Filed by the informant, my lord, here in this case, I am challenging the order of judgment of acquittal, wherein the eyewitnesses examination was declined by the prosecution and the London trial court, without considering their importance of the evidence, they allowed that the memo of declination and delivered the judgment by acquitting the accused persons. Paragraph D, I have stated in ground number D, I have stated their name. They were the eyewitness to the occurrence, but the declined memo was filed by the prosecution and that was allowed by the trial court. Their evidence was necessary for finding just decision of the case, Your Lordship.
Now, what you are doing at that stage?
I was not there because I was not appearing in that case. The prosecution, public prosecutor was looking after the case.
No, it's all right. If you are not vigilant at that time and you just kept mum and the prosecutor has its own choice, he may not examine all the witnesses named in the charge sheet. So, if of course, suppose there are some witnesses who, according to you, are the eyewitnesses, summons might have been issued to them, and after testing the witnesses, it might have come to his knowledge that they are not intending to support the prosecution case, and declining memo might have been filed. Who knows?
A declared memo was filed by the prosecution, public prosecutor.
So, in that way, how can you say that the
case of a murder
question
trial
is that the informant has a role so far as the trial court is concerned in a sessions trial? You can assist it and you can also file the written note of submission. That apart, you cannot conduct the trial, but you are not at all there in picture. You are not even filed any wakalatnama before the trial court. And
Yes,
it is not your case that you filed the wakalatnama and the trial court rejected the same. Now, the public prosecutor was conducting the trial. He has declined some of the witnesses, and the judgment shows that 10 witnesses were examined.
Yes,
So the charge sheet indicates that the total number of witnesses are 12 in number. Right?
Yes,
So
sir.
out of 12 witnesses, if the prosecutor has examined 10 witnesses, which is that witness according to you has been declined and he was a very material witness?
Anil Kumar Naik and Santosh Kumar Sabot. Your Lordship can have a glance to page 46, Your Lordship.
No. Anil Kumar Naik and Santosh Sabat have not been examined in the trial court.
No, my lord.
So,
And
are the eyewitnesses to the occurrence?
Yes, Your Lordship. Charge sheet, I have filed the charge sheet. In the charge sheet column, the IO has cited them to be the witness.
No. Have you annexed the 161 CRPC statement or 164 CRPC statement of those two witnesses?
No statement I
How
have
can
not.
we know that they are eyewitnesses to the occurrence?
Because
And,
I'll have at page 43.
On what date they were declined and what is the reason? Are they not summoned? Or
Yes,
they
they
were
were
summoned, they appeared in the court below, and after testing the witnesses, the prosecutor thought it proper to decline them.
Page 46, your lordship can level.
Page?
46. Order
Yes.
dated 27/11/2024.
Yeah. Order number, which order?
Order number 131 dated 27/11/2024.
Yeah.
Accused persons are present at file Sajira. One witness, Chakradhar Panigra, is present and examined PW9, cross-examined and discharged. SRF witness Santosh Sabat, about whom I am saying, back after personal service, but he did not turn up before the court. Hence, issue BW against the witness Santosh Sabat. ISC such and such. Witnesses, other SRF other witnesses Anil Naik and Sunil Panigrai are back after affixed service. However, issue press summon to arrest CS witness and the IO fixing CS to 4/12/2024 for trial. Thereafter, your lordship can have next page 47. Order dated 10/12/2024.
You are aggrieved for non-examination of which two witnesses?
Anil Kumar Naik and Santosh Kumar Sabat.
Santosh Sabat and Anil Naik, right?
Yes, your lordship.
Okay, you see in that very order, when it was found that Santosh Sabat SR was back after personal service and he did not turn up, so rightly the London Trial Court has issued bailable warrant of arrest against the said witness. And
Yes.
so far as the other witness, you saying that Anil Naik,
Yes.
that was back after affixture service, so fresh notice was issued. Then what happened?
47.
Then next, your lordship.
PP dropped.
Which one?
10, 12.
10/12/2024.
133 order number. PP dropped. Additional PP files a memo declining the rest of the CS witnesses. Close the proceedings evidence.
Even I am also possessing the statement of both the witnesses recorded 161, but that since I have not filed along with the paper book, I cannot show it because I am in virtual mode. But their statement is that they have seen the occurrence.
I filed those statements, let us see. This CRLA has been filed under section 419 of BNSS, challenging the judgment and order dated 24/12/2024 passed by the London First Additional Sessions Judge Barhampur in ST case number 32 of 2010. In acquitting the respondents number 2, 3, and 4, namely Tuna Patra alias Jagnu Patra, Giri alias Girish Chandra Sahu, and Mondu alias Santosh Kumar Sahu. Of the charges, the charge under section 302/34 of the Indian Penal Code. The sole contention of the London Council for the appellant, Mr. Mahapatra, is that the charge sheet would indicate, charge sheet as per annexure 2 would indicate that there are 12 witnesses, and in the trial court 10 witnesses have been examined, and the 2 witnesses who have been declined by the prosecution are Anil Naik and Santosh Sawant, who are the eyewitnesses to the occurrence. The learned counsel for the petitioner placed the order sheet dated 27/11/2024, which indicates that SR on the witness Santosh Sawant was back after personal service, but he did not attend the court for which bailable warrant of arrest was issued against the said witness through IIC Gosani Nuaga police station. And so far as witness Anil Naik is concerned, the SR was back after official service. The next order dated 4/12/2024 indicates that bailable warrant of arrest against Santosh Sawant was not executed and the SR was back so far as witness Anil Naik is concerned with personal service, and since he did not turn up, bailable warrant of arrest was also issued against him through IIC Gosani Nuaga police station. However, on the very next date, that is on 10/12/2024, when the bailable warrants issued against the aforesaid two witnesses, Santosh Sawant and Anil Naik, were yet to be executed, the learned additional public prosecutor filed a memo to decline the witnesses. The learned counsel for the petitioner submitted that the conduct of the additional public prosecutor in declining the eyewitnesses to the occurrence has caused serious prejudice to the informant, appellant, and which has led to passing an order of acquittal. Since the 161 CRPC statements of the aforesaid two witnesses have not been annexed to the criminal appeal memo, let the learned counsel for the appellant file the same with a memo, put up this matter on 14th of May 2025.
Can it be 13th or 15th?
Achha, 13th person, 13 of 5/2025. Yes.
I'm good.
Item 2.
Item 2. There is nothing that IS 637 of 2025 is filed for bail. Although it is confirmed by the petitioner that copy has served, but the copy is not available.
Which copy? Which copy?
IS 637 2025 for bail.
637.
That I saw, on 25th I saw.
And I am not disputing that the copy is not.
I'll supply another copy.
Give another copy.
I'll supply. Now I'm filing the data and supplying a copy also. In the meanwhile, pay a custodial certificate I'll call because I'm custody 17 year port.
Twice your bail application rejected.
IA number
637. When custody 17 years.
2025.
27/1.
This is an application for bail filed by appellant number 1 and 2. the learned counsel for the state submits that he is not having the copy of the interim application. Let the learned counsel for the appellant supply the copy of the interim application to the learned counsel for the state by tomorrow. Stop. Learned counsel for the appellant submit that the appellants are in jail custody for more than 17 years.
Yes.
Let the learned counsel for the state obtain the custody certificate. Which jail is now?
Chaudhar.
Chaudhar jail.
Criminal antecedent.
So also the criminal antecedent after summer vacation. Yes.
Obligations.
Item 3.
In this case, on 27/3/25, I undertook to file the surrender certificate. In that year, surrender on 25/3/25, and till date, I should not able to get that certificate.
You are, you have got the information that
25/3 this is surrender.
Dipali Mahapatra and counsel for the appellant submits that she has instruction that after availing the interim bail period as per order dated 18/12/2024 in Miss case number 1732 of 2017, the appellant has surrendered before the learned trial court. Stop. Since the learned counsel for the appellant is not producing the surrender certificate, let instruction in that respect be obtained from the learned trial court, and for such purpose the file be placed before the learned registrar judicial to call for a report from the learned trial court. Report of this matter after summer vacation with the report of the learned trial court.
Item 4.
I am appearing for the appeal number 1, my lord. And I have to send a letter to the appeal number 2, whether I can appear for the appeal number 2 also, my lord. Because Mr. Wanda was appearing for the both the appellant, my lord. He has been come forward. I don't have the brief, also copy of brief, mail. I may be allowed to be supplied with a copy of brief and a token type mail.
No, we couldn't follow the prisoner's petition.
Yes, ma'am.
Which has been received.
Yes, ma'am.
That is for appellant number 1.
Yes, ma'am.
To engage you.
Yes, ma'am.
So you have been engaged.
Yes, ma'am.
Why are you writing letter to appellant number 2?
Because Mr. Panda, say government official ହେଇଗଲେଣି ସେଥିପାଇଁ your lordship say
No, why are you writing letter? It would be a serious professional misconduct. तार जा हवा कथा सी लिखियो आपण गोटे क्लाइंट को मते एंगेज करंतु
नहीं सेटा in view of the fact that my lord last occasion this questions arose.
How you are writing such letter to appellant number 2 that please engage me as your advocate? ये जाकु चाहिए तार को दबो एंगेज करिवो नले सी appellant number 1 बेडिया सी प्रिजनर लिखिबो आपण को ये करिया को आपण कोन पई तांको लिखियो मते एंगेज करो बो. What do you want now?
Now I want that a copy of brief and LCR be supplied to me through pen
Copy
type.
of the
Copy of appeal memo, deposition and
appeal memo and deposition.
My
Mr. Gokulananda Sahu, Grand Counsel appearing for appellant number 1, submits that he may be supplied with the copy of the appeal memo. So also the copy of interim application copy अच्छी अपन पारे. So also the copies of the deposition of the witnesses examining the trial court in his pen drive. Let the registry supply the same to Mr. Sahoo in his pen drive. Yes, next, put up this matter after summer vacation.
Item 5.
And it says the last order, drafting 8/4/2025. So, you are to produce the custody certificate and also the criminal antecedent if any. Order lekha is bra. When counsel for the state seeks some time to produce the
Involvement of
Yes, yes.
that criminal PS case.
no, that is one aspect, but another aspect.
Custody certificate asking that time.
Acha. What is the result of this case? You have got another case that is 498A 406 4DP Act. What is the result of that case? Your wife must have been the informant in the case. So take instruction also in that. The Learning Council for the state has produced the written instruction dated 9/4/2025, received from IIC Barichandrapur Police Station, which indicates that the petitioner has got one criminal antecedent. However, the Learning Council for the state seeks some more time to produce the custody certificate. Stop. Put up this matter after summer vacation. The Learning Council ensuing summer vacation.
From the LCR is surrendered in 18/5/2010.
Put up the
Next week,
after summer vacation, the Learning Council for the appellant shall obtain instruction regarding the status of এটা କୋଉ PS ର PS case number 106 of 2013. In the meantime,
Balichandrapur dated.
Balichandrapur तो लिखा ही नहीं.
Judgment
लिखा ही.
another case.
No,
Another case.
it's another case. See, नियम की instruction मैंने. No. Yes, next.
Item 6.
अच्छा, this is to come along with so on. Yes.
In this appeal,
There is a prisoner's petition. What is your good name?
my name is Mrutyunjay Payal.
No, so prisoner's petition has come.
Because Martha and
No, N Panda, S Panda, and S Nanda at flag ABC.
my prisoner petition also there, man.
In the meantime, Mr. Swan was filed. How many appellants are there in this criminal appeal? One appellant.
I appeared on behalf of Amresh Pradhan, one.
Amresh Pradhan.
16 ହେଲାଣି sir.
ଅମରେଶ ପ୍ରଧାନର ପ୍ରିଜନର୍ସ ପିଟିସନ ଆଇଛି ଟୁ ଏନଗେଜ ମିଷ୍ଟର ଏନ୍ ପଣ୍ଡା, ଏସ୍ ପଣ୍ଡା ଆଉ ଏସ୍ ନନ୍ଦ। ଆଉ ଗୋଟେ ପ୍ରିଜନର୍ସ ପିଟିସନ ଅଛି ଫ୍ଲାଗ ଡି। ଫ୍ଲାଗ ଡି ଟା ଦେଖି କାହା ନାଁ ଅଛି?
ईश्वर कुमार दास। ईश्वर कुमार दास।
ସମ୍ପୂର୍ଣ୍ଣ
ବିକାଶ କୁମାର ଦାସ।
विकास कुमार दास।
ଶ୍ରୀନିବାସ ନନ୍ଦ ଲେଖା
then ବିକାଶ କୁମାର ଦାସ।
Last year, I think,
ଏଇଠି।
ऊपर
ଆଚ୍ଛା, ମୁଁ ବଦଳାଇ ଶ୍ରୀନିବାସ ନନ୍ଦ ଓ ତାଙ୍କର ସହଯୋଗୀଙ୍କୁ କୋଉଠି
ଶ୍ରୀଯୁକ୍ତ ବିକାଶ କୁମାର ଦାସଙ୍କୁ
କୋଉଠି
ସେଥିପାଇଁ ବର୍ତ୍ତମାନ ମୁଁ ତାଙ୍କୁ ବଦଳାଇ ଶ୍ରୀଯୁକ୍ତ
ଅରୁଣାଚାର୍ଯ୍ୟ ମୁଁ
ବିକାଶ କୁମାର ଦାସଙ୍କୁ
ଏଟା କେତେ ନମ୍ବର କେବେ
ଏଇଟା ହଉଛି ଆପଣଙ୍କର
ଲାଷ୍ଟ ବୋଧେ
248
ବିକାଶ କୁମାର, ଏଇଟା ହଉଛି ଡେଟେଡ 22/2/24। ତାପରେ ଆଉ ଆସିନି, ଏଇଟା ଲାଟେଷ୍ଟ ତାମାନେ ଅଛି 22/2/24। ହଁ ଠିକ ଅଛି, 22/2/24 ଅନୁଯାୟୀ ଆପଣଙ୍କୁ ବିକାଶ କୁମାର ଦାସଙ୍କୁ ସେ ଏନଗେଜ କଲା।
ଆଜ୍ଞା।
You are Mr. Vikas Kumar Das
Yes, ma'am.
and you have filed your wakalat now.
Yes, ma'am. I already filed, ma'am.
All right, view the prisoner's petition at flag D. Flag D, night, flag D, in which request has been made for engagement of Mr. Vikas Kumar Das as his advocate. Mr. Das has already filed wakalatnama. The prayer made in the prisoner's petition is accepted. The name of Mr. Vikas Kumar Das and his associates shall be reflected in the cause list henceforth. ଆପଣଙ୍କର ନାଁ ଅଛି ନା ନାହିଁ?
ଆଜ୍ଞା।
ନାଇଁ, except ଲେଖି ଦିଅନ୍ତୁ। Except the names of Mr. Vikas Kumar Das and his associates, the other names shall not be reflected in the cause list henceforth. କୁହନ୍ତୁ କଣ କହିବାର ଅଛି?
I pray that may be taken up next week with the file is not.
ନାଇଁ ନାଇଁ, ଏଇଟା କଣ? ଏଇଟା ତ କିଛି ନାହିଁ, ପିଟିସନ ତ ନାହିଁ କିଛି। ଆଉ ତ
Some defect is there, ma'am. It's for some manner.
leave that defect। 2018 କଣ defect? ଆରେ ଏଗୁଡା କଣ ପିଲେ ପିଲେ ଅଛି, ଏଟା କଣ ଆସିନି? ନେଇନି
5 years, ma'am.
You have not filed any application for condonation of delay? Or you have
Yes,
filed?
sir, I filed, madam. IN number 1278/18।
ଏଟା କଣ ଲାଇଫ ଇମ୍ପ୍ରିଜନମେଣ୍ଟ?
ଆଜ୍ଞା।
ଆପଣ ପ୍ରଥମରୁ ଥିଲେ ନା ଏବେ?
Subsequent, madam.
ଆଁ?
Subsequent, ପ୍ରଥମ।
ନାଇଁ ନାଇଁ, ଆପଣ
ଏଇଟା ଆପ୍ଲିକେସନ ଟା ପ୍ରଥମ ଫାଇଲିଂ।
ଆଜ୍ଞା।
ଆଚ୍ଛା, ଏ ଡିଲେଟା କଣ୍ଡୋନ କରିଦଉଛୁ, ଏଟା ଲାଇଫ ଇମ୍ପ୍ରିଜନମେଣ୍ଟ ଲେଖନ୍ତୁ। IN number 1278, ତା ଦେହରେ କିଛି ଅର୍ଡର ପାସ୍ ହେଇନି ତ? 1278 ଏଇ ସେ ଦେଖିଲ, ଲାଷ୍ଟ ଅର୍ଡର ହଉଛି 30/10/2018, ତାପରେ କିଛି ଅର୍ଡର ନାହିଁ। ଦେଖନ୍ତୁ, IN number 1278 of 2018, this is an application for condonation of delay. Considering the grounds taken in the interim application, and after hearing the land counsel for the parties, and since the petitioner has been sentenced to life imprisonment, we are inclined to condone the delay in filing the appeal. Accordingly, delay is condoned. I is disposed of. Hard admit call for the trial court record. Trial court record achi, very hard admit for me. Yeah.
Item 7.
That may be fixed, madam. That may be fixed.
1.8 हवा।
That man, this matter, I will find matter. Okay.
Well, file कौन तो बड़ा memo दे दे मैं पढ़ाया छुआ। Date कौन fix हो पड़ी? Yes, next.
Next is the option. I mean the second item, my lord. I have filed a application for interim bail. My father was granted interim bail for 3 years. That into consider his old age and different disease.
ବାପୁଙ୍କୁ କଣ ପାଇଁ ଦିଆଯିବ ନା ଫାଦର
Since there is nobody in my family married, my brother is also in custody married. Therefore, I prefer some time to.
No. What is that application?
My application mail 11/12 mail 25 11/12/25 mail.
This is filed by Pavitra Munda.
Yes, ma'am. Paragraph 5.
ଆପଣ ବାପାଙ୍କୁ ସେବା କରିବା ପାଇଁ ଯିବେ
ଆଜ୍ଞା
କାହିଁକି
ବହୁତ ଗୁଡା disease ଯାଇକି nobody is there. We both father and both brothers are in custody married. My father has been granted bail for 3 months married. And with much difficulty he released on bail on 23/25. Though bail was granted on 16/25.
ତାପରେ ସେ ପଳେଇ ଆସିବେ ଜେଲ ସେଇଠି ବାପାଙ୍କର ସେବା କରିବେ
ବର୍ତ୍ତମାନ ତାକୁ ଛାଡ଼ିଛନ୍ତି ସେ ଇଏ ପାଇଁ
କାହିଁ ଯାଉଥିଲେ
ଡିଜିଜ ପାଇଁ
20/3/2025 ତ ହେଲାଣି 2 ମାସ ହେଇଯିବ ଆଉ କିଛି ଦିନ ପରେ ଯଦି ଯାଇଥାନ୍ତି ଏଇଆ ତାଙ୍କୁ 3 ମାସ ଦିଆଯାଇଛି ନା 3 ମାସ ତ 26 ରେ ସରିଯିବ ଆଉ ବାପାଙ୍କର ସିଏ ତାର ଯାଇଛନ୍ତି ହେଲ୍ଥ ଗ୍ରାଉଣ୍ଡରେ ଆପଣ ଯିବେ ତାଙ୍କୁ ଟ୍ରିଟମେଣ୍ଟ କରିବା ଗ୍ରାଉଣ୍ଡରେ ତାପରେ ଆଉ ଗୋଟେ ଆସିବ କହିବ ମୋ ଭାଇ ଇଏ ଅଛନ୍ତି ଏ ପଇସା ଆରେଞ୍ଜମେଣ୍ଟ କରିପାରୁନାହାନ୍ତି ମତେ ଛାଡ not your bail application has been rejected on merit.
No, ma'am. That is right.
Remove the bail application on merit.
Some 15 days will also stand.
IN number so and so. This is an application for interim bail. After perusing the grounds taken in the interim application, we are not inclined to grant interim bail. Stands rejected. The IN number so and so. This is an application for bail. Land and counsel for the petitioner 6 for an adjournment. Put up this matter after ensuing summer petition. Yes, next.
Paper book is ready.
Since the paper book is ready, the same may be supplied to the land counsel for the appellant in the meantime.
Item 8.
Yes, 1 minute.
Last you will have to directed
Just a minute. Surrender certificate you have not. The land counsel for the appellant filed the surrender certificate which is taken on record. Yes, next.
Item 9.
Is your option? I am appealing for the appellant number 2 in the present appeal. The Lordship by order dated 23/2025 was pleased to grant me a week's time on the ground of attending to the obsequies of my widow sister. I have surrendered and filed my surrender certificate by 22/4/2025, but that is not available on.
कितने
22/4/25 को मैं मेमो रे surrender certificate file करती हूँ.
Mr. Panda, Land Counsel, Sudhir Panda, Land Counsel appearing for the appellant submits that the appellant number 2, after availing the interim bail period, has surrendered in the trial court, and he has also filed the surrender certificate with a memo on 22/4/2025. Let the registry place the same on record. Yes, after summer vacation.
Item 10.
He has surrendered on 5th of April.
ना ठीक है सरेंडर डेट हमें दो ना हमको जो मेमो डेट हो जी 22/4/2000 दैट्स ऑल यस नेक्स्ट
Item 10.
Last time, what's the directed to Spectrum instruction? The status of the doctor lordships. I know, doctor.
12/3/2025 during course of urban petition of the husband of the deceased and marriage, the occurrence in question took place once, so they are blessed with a daughter. Nothing has been stated about the status of the daughter. अच्छा कौन हल्ला That 498 304B. What is this sentence imposed? Life imprisonment.
Minor.
Custody period?
The minor. About 7 years lordships, not 2 months. But as per instructions concerned, as the daughter is concerned, so that my concern is my lord. The daughter has been staying at President Doctor District Mahila Committee, Malkargiri, my lord.
No, he has not obtained the instruction. And the custody certificate you have produced? You have obtained it? Achha, the Land Council for the state seeks some more time to obtain instruction relating to the status of the daughter of the petitioner as per the order dated 12/3/2025.
Item 13.
Yeah.
Alias will file for interim bail application also of the appellant number 1.
Which one?
IA number 1177. It has not been on record.
IA number?
1177 of 2025. Interim bail on the ground of his own in-laws. Both the kidneys have been failed.
Achha. You have got a copy of that?
There is no copy.
Serve a copy on the Land State Council.
Documents are there?
No document because is in custody and
Achha.
both.
IA number 1, the Land Council for the appellant submits that he has filed an interim application, that is IA number 1177 of 2025 for interim bail of the appellant. Appellant na appellants?
Appellant number 1.
Appellant number 1, Ganeshwar Bastia alias Ganeshwar, on the ground of his ailment and stop. Let a copy of the interim application be served on the Land Council for the state, who shall obtain instruction on the same to the concerned jail superintendent, put up this matter on who jail achandi janna di asi kon instruction debe
I'll supply.
ଆପଣଙ୍କ କ୍ଲାଏଣ୍ଟ ଆପଣ ଜାଣିବେନି ଆଉ କିଏ ଜାଣିବେ put up this matter after ensuing summer vacation.
Item 15.
Item 15.
Lordship, I am absent for opposite but number 2.
Who is Mr. Rabinaran Behra? Not there. Condonation of delay.
Yes, sir.
What is this criminal appeal for?
Lordship.
Acquittal or conviction?
Acquittal.
Acquittal. You are for the accused.
Yes, sir.
Have you filed your objection?
No, your Lordship.
You don't want to file any objection?
Yes,
to
sir.
the-
Lordship.
So if you have already entered appearance and there is delay of 488 days,
Yes, sir.
if you intend to file, otherwise you will condone the delay.
Yes, sir. Lordship, my fix the short date Lordship will file.
Because it's a 376 and 3 SCST is there.
Yes, sir.
So
State is not filing appeal.
Lordship, last provision Lordship directed to the state to.
I have obtained the instructor manual.
not willing to file.
I will.
Don't worry. The Learning Council for the state has produced the written instruction received from এটা कौन लिखছেন?
Not yet decided.
Not yet decided. What time?
You see, this communication by you is wrong. You should not have communicated to the IIC Mohila police station. Who is he to say? Who is he to make necessary? Director of Public Prosecution is supposed to take the opinion from the concerned public prosecutor of the trial court, and he will verify the judgment and will say that these are the points on which the appeal against the acquittal can be referred. What the IIC will do, and why have you written letter to the IIC? Make proper correspondence to the person concerned. Director of Public Prosecutor, you make the correspondence. The Learning Council for the state, though, has produced the written instruction received from the Inspector in charge of Mohila Police Station, Raurkela, dated 8/5/2025. However, he submits that you may be given some more time to obtain authentic information to the Director of Public Prosecution as to whether the government is intending to file any appeal against the impugned judgment and order of acquittal. Stop. IA number 1565 of 2024. This delay has not been condoned as yet.
No, Your Lordship.
This is an application for condonation of delays. Mr. Pushpamitra Mahapatra and counsel appearing for the, you are appearing for whom?
Opposite party number 2, Lordship.
That is the accused.
Yes, Your Lordship.
For the accused, seek some time to file objection to the delay condonation application. You have given number of adjournment for that purpose.
Lordship.
At least 3 na 4 adjournment nahi sarleni.
Lordship, last time, Lordship. Lordship, only 5.
Put up this matter after summer vacation. Objection, if any, to the delay condonation application be filed in the meantime. Mayor.
Item 16.
Yeah, that's the criminal appeal, where appellant challenged order dated 16/4/2021. Additional session judge Contempt convicted the appellant with 452/302 malad of life imprisonment and imposed fine.
You
for
have
RI
received
6
the
months.
copy. Paper.
Here, malad, the allegation, the complainant in his complaint said the appellant and 4 others entered in the house and assaulted with the Interim Article Act, for which ballot on
Who is
spot
the deceased?
deceased.
What is the name of the deceased?
Vichitra Benia.
Vichitra Goria.
Benia.
Benia.
Man.
Vichitra Benia.
Benia.
And when the occurrence took place?
10/11/2017.
Eyewitnesses are there.
Eyewitness, on basing of an eye.
How many eyewitnesses are there?
Only wife, man.
No, my lord, 2 eyewitnesses.
What are they? Who are they?
PW 5 and PW 10.
5 and 10.
PW 5 and PW 10.
10.
And who is the doctor who conducted PM?
Dr. Malad,
Dr.
PW
Meher Malad, PW2,
PW 8.
8 Malad.
Okay, you come to one eyewitness statement. Let us see that. PW 5.
5 Malad.
Please place
49 Malad. 49.
Hold on.
I am the informant of the case. I know the accused who is standing in the dock. I also know Bhuban, Keshav, Rudhava, and Shamo Benia. Near 2 years back, on the 10th day of October in the evening hour at about 7 p.m., myself and my deceased husband sitting in front of our house and warming ourselves by sitting in the firewood. By that time, the accused and the above-named person entered inside my house and then came out. All of a sudden, the accused dealt 3 blows by means of a tabal on the hand of the husband, head of the husband, for which my husband sustained several bleeding injury and died on the spot. He also threatened me, saying, as Dari Poti Luchichu, due to land dispute
the accused killed my husband. I lost affair. I was examined by the police.
So same person has been stated by PW10.
PW 5
Same.
wala, मतलब 10.
PW10 मजा से कथा कौची तो.
Mala.
So you assaulted by means of a tabal on the head.
Mala.
And the doctor who conducted PM, he has noticed two injuries on the skull, and those are lacerated wound size so and so, and cause of death is due to hypovolemic shock due to injuries on. Direct evidence is corroborated by the medical evidence.
So far as my medical report is concerned, there is no nexus. The forensic laboratory has just given the report. There is no nexus with the tabla axe, by no blood at all. And so far as the 27 of Evidence Act, the seasoning increment article, the witness, in presence of a witness, they totally deny. Then in our presence, the such and such increment article has been seized.
So se apon kochen se jo tabal taru blood baharlani beli acquittal karajibo na.
Nahin, tabal blood baharni jo seize heichi, police seize karichi. The evidence in presence of evidence seize haba katha. The witness achandi seman totally deny.
Let us say that seizure is disbelieved. And suppose the weapon of offense would not have been seized. How do you get over the evidence of the two eyewitnesses coupled with the medical evidence?
5 and 10.
जे मारिबो से ताबल को बा वेपन को ऑफेंस को से रक्त लगे किनी कोठी नुचेबो बोले एमती तो किछि माने नाही तेणु क्षेत्र ये कले बाहरिबोनी रक्त ऑब्वियसली तेणु बाकी आई विटनेस दीटा जो कहउछन्ती आपण मारले मुंडरे मारले दीटा
तिनी चोटो मारिला लेट्स कैन गन एफएक्स
इंजुरी अछि हेड रे इंजुरी अछि केते वर्ष रहलेनी
8 वर्ष 17 वर्ष
कौन करंती आपण को एंटीसीडेंट कौन अछि
एंटीसीडेंट किछि
मगाइनी मगान एंटीसीडेंट मगान तो कस्टडी सर्टिफिकेट प्रोड्यूस कर लेखन the Land Council IA number so and so, this is an application for bail. The Land Council for the state takes some time to produce the custody certificate as well as criminal antecedent if any against the appellant because this matter after ensuing summer vacation. Yes.
Item 17.
Summer vacation. Next.
Item 18.
Surrender certificate, I have not obtained the surrender certificate. No, surrender.
जाइतिले बेल की.
Already surrender in right time.
Interim bail is allowed. 24/25 रे ଆପଣଙ୍କର ବଡ ବାପା ଏକ୍ସପାୟର୍ଡ କରିଦେଇଥିଲେ ସେଥିପାଇଁ ଆପଣଙ୍କୁ ବେଲ୍ ଦିଆ ହେଇଥିଲା 2 ସପ୍ତାହ ଦିଆ ହେଇଥିଲା କୁହାଯାଇଥିଲା ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ ସରେଣ୍ଡର ସାର୍ଟିଫିକେଟ କାଇଁ
Certificate only open coupon.
ହଁ
There's a pipe and set apply.
ଆଚ୍ଛା କିନ୍ତୁ ସରେଣ୍ଡର କରିସାରିଲାଣି
Right time is.
ଦେଖନ୍ତୁ the running counsel for the appellant submits that after availing the interim bail period as per order dated 24/2/2025 in IA number 607 of 2025, the appellant has already surrendered before the Land Trial Court, but he is not able to produce the surrender certificate. Let a report be called for from the Land Trial Court in that respect, and for such purpose, the file be placed before the Land Registered Judicial, who shall intimate the Land Trial Court to send such report. Yes, next, after summer vacation.
Item 18.
Your Lordship, after vacation. After summer vacation.
Item 19.
Yes, Mr. Mishra.
On behalf of Mr. Mishra, Remal appropriate.
Next.
Item 20.
14 years, 4 months in custody, madam. And
State has produced this one, so which is taken one person, petitioner has got 8 criminal antecedent. Obtain instruction kind, comprehensive affidavit. File kale? The learned counsel for the appellant seeks some more time to file the comprehensive affidavit relating to the status of, I'm sorry, the criminal cases.
I filed, madam. I filed. I'm sorry, sir. I have the copy. Just copy. I filed it.
जब फाइल कर ले
21st of March 2025.
Acha, the learned counsel for the appellant Mr. Chand submits that as per order dated 28/2/2025, he has filed the comprehensive affidavit. The registry may place the same on record. You have received the copy?
No, I have not.
I'm going to copy you. Let a
All
copy.
the case led to 2000 before 2011.
I'm going to give to copy to you. Let the same be placed on record. Yes, next.
Maybe before the
After summer vacation. Next.
Item 21.
Effect number 7 not removed. बाकी रहा condonation of delay. केते दिन अछि delay 87 days. आपण एटा कोन life imprisonment?
Let's see.
IA number 2845 of 23 is an application for condonation of delay. The stamp reporter has pointed out that there is a delay of 87 days in filing the criminal appeal after hearing the learned counsel for the parties. And since the petitioner has been sentenced to life imprisonment, we are inclined to condone the delay. Accordingly, delay is condoned, IU is disposed of, hard admit call for the trial court record. The interim applications for bail and stay relation of fine to be considered after the receipt of the trial court record. Learned counsel for the appellant shall supply the deposition copies of the witnesses to the learned counsel for the state in the meantime, who shall produce the custody certificate as well as obtain instruction relating to the criminal antecedent if any in the meantime. Yes.
Item 22.
Miss Vinapani Tripathi. Actually, your lordship may be noting, since Miss Tripathi has joined State Council, another Miss Nandini Tripathi's name there. No, the prisoner petition is also. Vinapani Tripathi ଅଛନ୍ତି ପୁରା ତା ସାଇଡ୍ ରେ ନନ୍ଦିନୀ ତ୍ରିପାଠୀ ଲେଖାଇଛି ନନ୍ଦିନୀ ତ୍ରିପାଠୀ ଆଚ୍ଛା ବିନାପାଣି ତ୍ରିପାଠୀ ଜଏନ୍ କରିଗଲେଣି ଏଠି ଆଚ୍ଛା ନନ୍ଦିନୀ ତ୍ରିପାଠୀଙ୍କ ତ ନାଁ ଅଛି ମ୍ୟାଡାମ ଅଛନ୍ତି ହଁ ତ କରିବେ କଣ କହୁଛନ୍ତି କରୁନାହାନ୍ତି କଣ ପ୍ଲେସ୍ କରୁନି ମ୍ୟାଟର ଆରେ ଛିଡା ହେଇଯାଉଛନ୍ତି ମୁଁ କହିଲି କଣ ହବ
Today, have you prepared or you want adjournment? What?
After summer vacation.
After summer vacation.
After summer vacation. So, Miss Nandini Tripathi, learned counsel for the appellant, seeks for an adjournment. Please this matter after ensuing summer vacation. Yes, next.
Item 23.
Yes.
Item 24.
Yes.
Item 25.
My regular. The appellant has been custody from
T2/2018. Okay, I think it's custody is
ଅଛି custody certificate କେବେଠୁ ରହିଲେଣି କହୁଛନ୍ତି
T2/2018.
ଆଚ୍ଛା IN number so and so, this is an application for bail. Mr. Bhasdev and counsel appearing for the appellant submit that the appellant, single appellant though?
Single appellant.
That the appellant is in judicial custody since
3/2018.
3/2018. Let the learned counsel for the state produce the custody certificate, so also obtain instruction regarding the criminal antecedents if any, against the appellant put up after summary office. Yes, sir.
Item 26.
Lordship, paper after when?
Yes.
Item 27.
Here be the lordship. Last step is lordship for direction, let the matter wait some time period. Last step is I go add this bail application and wait some time. What happened, Miller? This is a rape and murder case. One is from the life penalty. There is no witness. The petitioner, the appellant was convicted for life. And the PDO on the basis of circumstances, PDO 9.
Have you received the deposition?
Yes, I get all the everything. Postal certificate. There is no.
What is the offense?
376. 376(2)(11) section C 302B. It is a jail custody more than 10 years.
No, it's a rape of a minor girl or not?
Minor.
Actually, age is more.
The petitioner was convicted for life. He was in custody since
2017, my lord.
Got the certificate
No,
and criminal antecedent.
my lord.
Let me know the IA number 148024. This is an application for bail. Land counsel for the state seeks some time to obtain the custody certificate. So also instruction about the criminal antecedent against the petitioner effect of this matter after some other petition. Next.
Item 30.
May I please? Chairman, the appellant convicted under section 376(1) for 7 years, madam, and for offense under section 32E of madam for life, madam. During trial, he was on bail. And now he is in custody since.
What about the notice
Notice has already been served. madam.
served? Non appears for the victim as well. So victim has been examined as PW
21.
21. Custody since? When you say?
Beg pardon, madam. Custody since madam is 27/5/2020.
2020,
24 months.
24.
During trial, he was on bail.
Not exceed.
What decision fill
Sir, notice for judgment, W7336 of 2020.
We dismiss the writ petition on the ground that the cause of action arose in favor of the petitioner suffers from delay and laches.
I agree.
Item 31. Item 32.
Deposition copy paichanti? Yes, Mr. Mulya.
TW2 is the main eyewitness and mother.
Item item 33. Carelessly, trial no, reproduction.
17/10/2019.
17/10/2019. This is not on.
This is Santosh Singh.
Santosh
Singh.
Date of occurrence.
12/3/2019.
12/3/2019.
11/3/2019.
11th year. Sole eyewitness.
Yes, ma'am.
PW2. Dr. K.
Dr.
Schedule 5.
PM doctor.
PM Doctor, Schedule 5.
দুই কো পড়ে আসুন পড়ুন।
I do not know the informant. I know the accused standing in the dock, who is my husband. This is Santosh Singh is my son. The incident took place on 11/3/2019 at about 11 p.m.
Just a minute. Yeah, this is with my son. Accused is my husband. Papo Kumarchi.
Stepson.
ତା wife ର ଆଗରୁ ପୁଅ ପିଲାଟା ଥିଲା ସେ
Out of a sudden quarrel, my
ପଢ଼ନ୍ତୁ।
At the time of incident, myself, my deceased son, and my husband were staying in the said house. On that night, my husband returned to our house after driving. On small matter, quarrel started between us, and the accused beat me. I had married earlier to Sanjay Singh and was blessed with a son named Santosh Singh. When Sanjay started beating me, I left him with my son and married to the accused. On the date of incident, due to our quarrel, the accused killed Santosh by throwing him on the cement wall of our house. Due to such assault, Santosh sustained bleeding in his head and fell down on the ground. The deceased gave kick to Santosh and stand up on the stomach of Santosh. My son vomited and died at the spot.
କେତେ ବର୍ଷ ହେଇଥିଲା?
5 ବର୍ଷ।
5 years.
The postmortem report also says that
ଆପଣଙ୍କ ସ୍ତ୍ରୀ ଆପଣଙ୍କ ବିରୁଦ୍ଧରେ କହୁଛି ସାକ୍ଷୀ ଦଉଛି ତଳେ ପକେଇ ଗୋଇଠା ମାରି ତା
See the manner of the gruesomeness.
ରକ୍ତ ବାନ୍ତି କରି ମରିଛି।
Gruesomeness.
No intention.
No intention.
I just said something.
If you are assaulted your wife, well and good. This small child, 5 years,
5 years child,
and you threw it, then dashed against the head in the floor, and then
stood over in the
stomach and vomited.
When person is stated my lord, I am not stated before that accused killed my son.
No, see, generally you put no, but this statement must have been there. The upare chidai ne uda ko nahi. पेट ऊपर छिड़ाला से रक्त बांती कला से स्पॉट रे मरीगला पूरा सब थिबु निश्चय गोटे वार्ड आड कर दी तो से ओडा को पचार दैथियो And
never misutilize the liberty and
that's summer vacation for you. Next.
Item 33.
May it please your lordship. 302 section 34 injunction driver petitioner and another Somaru Dura they faced trial.
ये डिपोजिशन कॉपी अच्छी केबेटू कस्टडी रहलिनी
21/2/22
21/2/2022 दिस इज नाउ फ्रॉम
गणपति तंती
गणपति तंती
my lord.
आई विटनेस अछंती
Eyewitness man. Last scene theory.
जस्ट अ मिनट आई विटनेस की कोन
Eyewitness ना
ना दिनो
admitted.
कौन कौन अच्छी सर्कमस्टेंसेस है उधर
Circumstantial like the last scene theory
हाउ कौन
and confession by one of the co-accused, one accused, not this petitioner,
confession of who accused
co-accused, and section 27 of the fourth accused.
at your instance
No,
how
the other accused.
Co-accused.
नहीं आपन को इंस्टेंस से किछि रिकॉर्ड
Night teaching.
लास्ट इन की कोची
Last scene theory 5 and 6.
PW 5 and 6
27 to 7 and 12.
नहीं 27 तो आपन
आपन नहीं ना
Nine.
PW 5 and 6
Confession is also not in my mind. Only Somaru Dura.
5 and 6 कोठी देखिले डेड बॉडी कोठ मिलला
Last time they they said last time they were sitting in their house and taking liquor with the deceased. Thereafter they went to witness Nata. When they returned, the deceased was not there.
so after taking liquor with the deceased
They went to see witness Nata.
अच्छा
They returned. When
they returned means this PW 5 and 6 returned
no,
the accused returned
both the accused.
both the accused
They returned.
and,
The other man was not there, so that was asked. Thereafter, it is said that the
so what is your explanation in 313 statement आपन संगरे जा प्रश्न पचरा आइथिबो ना 5 313 आपन
313 मो पाखरे ना
नहीं अच्छा 313 टा देखियो 5-6 विषय कोड पचरा आइ और खाली मिछ कथा कहते कोई थाते गोटे ଯାଇଥିଲା ଆମ ସାଙ୍ଗରେ ସେ କହିଲା ମୁଁ ଯାଉଛି ଆଉ
ଗୁଡାଏ ଜିନିଷ ସେଠି ଯୋଉ ପ୍ରକାର ଟ୍ରାଏଲ ଚାଲିଛି ଅନେକ ସମୟରେ ଟିକେ
ସିମ୍ପଲ
ଦୁଃଖ ଲାଗେ
କହି ଯାଇଥିଲା ମତେ କହିଲା ମୁଁ ଯାଉଛି ଘରକୁ ତାକୁ କଣ ନିଦ ଲାଗିଲା ପଳାଇଲା ତାପରେ ଆମେ ଜାଣିଲୁ ମିଛ ଜଷ୍ଟ ଏକ୍ସପ୍ଲାନେସନ
ଅନେକ ସମୟରେ କିଛି ପ୍ରଶ୍ନ ପଚାରୁନାହାନ୍ତି ଯୋଉଟା କି ଇଜିଲି ପଚାରିବା ଉଚିତ
ଷ୍ଟେଟ ଡିଫେନ୍ସ କାଉନସିଲ କରିଥିଲା
ନାଇଁ
ଆଉ ଆପଣ ଦୋଷ କେମିତି ଦେବେ କଣ
ନା ଦୋଷ
privately वकील engage करियो yes what else is there the last scene dead body के दिन पर मिलना
सही दिन
कोडी मिलला
एक बड़े कलवर्ट रे पड़ी माने मोटरसाइकिल रे फेरला मोटरसाइकिल रे जाइथिले बड़े कलवर्ट रे पड़ी थले
ते नाटो जो जागारू सेठी केते वाट थेडा
सेठू हम प्राय 7-8 किलोमीटर
एविडेंस अछि से पाखापाखि केही देखि ना जो डेड बॉडी पड़थला सेठी पाखर के दी जण को देखि ना
नहीं
No, I think 27 is also read against you. Just see question number 14.
Only Somaru
statement. No. Statement. Your statement. 313 statement. It is further transparent from the evidence that when they were asked about Ganapati and you two remained silent, and after being asked repeatedly, you both disclosed that you killed and threw away Ganapati, but did not disclose the place.
That statement has been made by a witness, Somaru Dura, not by me. PW 5 and 6, they have said, they asked, Somaru Dura disclosed all this statement, not me.
Extrajudicial confession is also there.
That is extrajudicial.
No, PW 5, actually PW 5.
5 and 6.
I along with so-and-so had gone to the house of the Krishna in the evening hours. I saw so-and-so taking alcohol. यादेरे गणपति अच्छी
ଅଛି
ଆଉ ମାନେ डिसीज्ड अच्छी ଆଉ ये गुरु ଆଉ
Guru,
माता
Mata,
Guru Mata,
Guru.
both are accused.
अच्छा ଏଟା କେତେ ନମ୍ବର
Guru means you.
Guru means me.
ଆଉ ଏ as a single appellant
It's a single appellant.
Single
Only Guru is the appellant.
ମାତା ମାତାର କଣ ହେଲା
Mata I do.
ନାଇଁ ନାଇଁ ମୁଁ କହିଲି after conviction ହେଇଛି ନା ନାଇଁ
हाँ है सी.
ଆଚ୍ଛା after some time they left the house to see Jatra to Bija other village in the motorcycle of Krishna. Acha. We too were in Krishna's house. After some time, I along with so went to in another way towards Jatra. Searched for the three persons in the Nata. Did not found him. After watching Jatra, we three returned at about 2:30, and on the way, Anta colony, we saw the bike of Krishna on the road. And Guru and Mata were
Present in the house.
present in the house.
Taking liquor means they have not gone with them.
But
They remain in the house. They
Ganapati
remain.
was not there. Krishna identified his bike and we detained there. When we asked Ganapati, which they remained silent after being asked repeatedly, they disclosed they killed so-and-so, threw away Ganapati. And they did not disclose about the place. We came back to Krishna house, left Krishna there, and out of fear, I along with so-and-so have disclosed this statement so-and-so. Yeah. How this Pusparaju Gopal,
Pusparaju is the informant.
PW कहते हैं
PW1. I'm sorry, PW.
Pushparaj 3.
No.
Pushparaj Gopal. Pushparaj
PW3.
3.
PW3.
Informant.
Please paste the statement, let us see.
I am the informant. I am the informant in this case, but do not know the accused person and the deceased name suggested by P2. On 19/2/2022, at 4 p.m., I got information about a body lying under a culvert in 40 Hantal, Dongar, in between Dongola and Katameta. I, along with other co-villagers, went to the spot and saw a body lying in pool of blood under the culvert. I telephoned to Malkangiri PS and informed about the body. Police went to the spot and in our presence took out the body from the culvert, and then we saw there was a cut mark on the front side neck of the deceased and profuse bleeding was there. IIC directed me to submit a written report, and accordingly I lodged the affair being
Scribed by Pavitra.
being by Pavitra Farai, a teacher. I signed on the affair. Exhibit P1 is the affair, and Exhibit P1/1 and P1/2 are my signatures therein. Police made inquest over the body in our presence. Exhibit P2 is the inquest report, and Exhibit P2/1 is my signature therein. The vehicle used to pass over the culvert under which the body was recovered. The villagers first saw the body while cultivating their land and accordingly informed us. I was examined by the police in this case. This is my first.
This extrajudicial confession is also there
Minor.
because it was a joint statement
Minor.
as it appears from the evidence of PW 5 and 6.
That is
Both
true,
of
but
them-
the PW 17 says
When we asked about Ganapati, to which they remained silent,
they remain
and after being repeatedly, they disclosed that they killed. That is the evidence of
PW 5 and 6.
That was put to them, put to the accused in 313 also, question number 14.
So these are the two circumstances against you. Even though that leading to discovery is not there, that was found, the body was found as such. So these are the two.
And the blood was also given recovery by the other accused.
What do you say, Mr. Nayan?
The statutory conference was there, Schedule 6 also there.
5 and 6.
Five.
Same.
Both.
Same.
So, is it a voluntary one? They were not telling anything. They repeatedly asked, and they were under the influence of liquor and said this statement. And it is to be ultimately adjudicated at the trial, but
Custody period.
21 to 22.
Land counsel for the petitioner, land counsel for the state. Land counsel for the petitioner submit that the petitioner is in judicial custody since 21 to
222.
21 to.
My lord. 21-22.
And there are no eyewitnesses to the occurrence. The case is based on circumstantial evidence. Main circumstance is the last scene of the petitioner in the company of the deceased. So also the joint extrajudicial confession which has been deposed to by PW5 and PW6. The land counsel for the petitioner submits that in absence of any other material on record, basing on these two circumstances, it is very difficult to sustain the conviction of the appellants in the
Only one
alleged appellant in the alleged crime. There are good chances of success in the appeal. Balance of convenience is in his favor. Therefore, the bail application may be favorably considered. Land counsel for the state placed the evidence of PW5 and PW6. So also the doctor PM Schedule
13.
also the doctor bracket PW13 who conducted post-mortem examination over the dead body and opined that the cause of death was due to asphyxia and hemorrhage and shock due to deep throat injury, which was anti-mortem in nature. Considering the submission made by the learned counsel for the respective parties, absence of any direct evidence, nature of circumstantial evidence on record, period of detention of the petitioner in judicial custody, and absence of any chance of early hearing, we are inclined to release the petitioner on bail allowed. Yes, next case.
Item 34.
Yeah. Convicted under section 302, 341 by 34.
I think the deposition copy.
Paper book
here, and yes, what is the conviction?
302, 341 by 34 IPC.
Direct evidence.
Well, direct evidence. PW 9, 14.
Just a minute. PW 9.
9, 14.
Yes.
19 and 20. Are the eyewitness to the
They are the
occurrence.
eyewitnesses. Who is the doctor?
And doctor is PW 18, madam.
PM doctor.
PM doctor.
You are in custody since when?
Since 26/6/2020.
26/6, 26/6/2020. This is now कौन?
This is now Digambar Sahu.
Digambar Sahu.
Digambar Sahu.
Date of occurrence?
23/6/2020.
ଗୋଟେ eyewitness को आसंगे
All the three eyewitnesses are stated omnibus manner, but
PW 9 is there. PW 9 is there.
9, PW 9 कौन 9 is the informant as well as eyewitness. 9, 14, 19 and 20, out of which 14 has specifically stated regarding, all have omnibussly stated that all assaulted.
14 has specifically stated against you.
14.
1/4
yes, se role ta kahichi. how I know the informant, she is my mother-in-law. I know that this is Digambar Sahu, he is my brother-in-law. I know both the accused persons standing in the dock. About 3 years back, one day at early morning, while Digambar Sahu was proceeding towards agriculture, and these two accused persons, along with Sona Deuri, Siddheswar Boi, attacked him being armed with axe. Accused Babulu dealt axe blow to him. Accused Sona Deuri caused injury on his head by a kati. Accused Siddheswar Boi beat him with iron rod, and accused Manoj beat him with stick. And at that time, informant was following the Digambar Sahu towards the agricultural land.
So, just a minute. You are the only person who was holding a
stick.
And so if the doctor's evidence is taken into account, then the injury number 4, that is a lacerated wound over the scalp, that is possible with that stick.
Yes, but another person who was assaulted by means of iron rod. Accused Siddheswar Boi beat him with iron rod.
बाकी गुड़ाक सब चॉप वुंड अछि और स्टैब वुंड अछि ए गोटी इंजरी अछि लैसेरेटेड ओवर द स्काल्प और से PW14
PW9 also stated
नहीं से इटा स्पेसिफिक होची बोली से कहउछन आपण एक्यूज ये होची मनोज तो मनोज assaulted by means of a stick
and all other witnesses are not telling specifically anything.
No, all of omnibus
Siddheswar assaulted by iron rod.
Iron rod.
How cross examination कौन बाहर करचंती?
And then in Para 3, he is also a witness to disclosure statement. He stated that who accused that Digambar Sahu, that Siddheswar Boi, he confessed before the police, and only axe, kati and iron rod were found inside after 3 months, it was found from the...
What happened to that accused who has used that iron rod?
Iron rod, Malat, he has not faced trial.
Siddheswar Boi.
Siddheswar Boi.
Or he has not been charge sheeted or what? Or he absconded?
Malat, after copy of charge sheet.
Siddheswar Boi.
All have been charge sheeted.
Iron rod.
Siddheswar Boi. Yes, Malat. No, he was arrested, Malat. 11/9/2020
judgment copy to the nine Siddheswar.
Siddheswar nahi, kintu he is arrested on 11/9/2020 because his disclosure statement was recorded after 3 months.
No, ठीक है जी. तार trial ले कौन हला?
तारा trial for trial phase.
तो तीजोन चार्ज शीट करनो
चार्ज शीट 4 जण on.
4 जण तो 3 जण अछन अब दीटा कोडा.
अब जणे एब्सकॉन्डर अछि.
तमन ये ट्रायल फेस करती हूँ सिद्धेश्वर मनोज साहू तारंगधर ऋषिकेश सिद्धेश्वर केते नंबर चाहे
तर पैराग्राफ 4 रे लिखा है the same as transport the case against the Hrusikesh alias Siddheswar Boi was split up as he did not appear before this court, and accordingly MPW was issued against him.
अच्छा कारण चार्ज शीट भी देखो जी सिद्धेश्वर Boi
was arrested
on 11/9/2020
मतलब
तापर से बेल ले जाएंगे
बेल ले जाके एब्सकॉन्ड कर
how many criminal antecedents?
No antecedent Malat have Malat. And throughout the Malat period I have been custody. That is also in the judgment. It has been appended custody certificate. I mean custody since 26/6/2020. And Lathi is also not seized by the police also. Weapon of offense, it is marked. Lathi is also not seized.
ये आ हत्यारे से को
PW9 में PW9
आपनकर जो 14 नंबर साखी एविडेंस अनुଯାयी ये मारला कोथरे स्टिक रे
Stick रे.
See, the stick and the axe were lying in the spot.
All weapon of offense were lying at the spot, but subsequently all are
TW 19 said that.
who accused was arrested and his disclosure statement was recorded, and it was shown that it was found from the well. It was recovered from the well, and this weapon of offense, that is 3 weapon of offense that has been marked as MO1, not specifically marked.
The iron rod and bhujal.
Iron rod,
PW9
bhujal,
stated
and
that.
copy.
May I place me the PW9 statement?
Huh.
On that day at about 6 a.m., I, along with my son Digambar, was proceeded towards our agricultural land. Digambar was walking little ahead of me. At that time, the accused person, namely Sona Deuri, Babula Deuri, and Manoj Sahu, the petition, restrained Digambar and attacked him with a kati, iron rod, and bhujal.
What about stick? दिगंबर उपरे कोनोची स्टिक रो माड़ हवा PW9 कहिछि any of the accused was armed with stick. Has he stated that?
No, that.
Then ଆପଣଙ୍କର ଗୋଟେ ସାକ୍ଷୀ କହୁଛି ଯେ ଏଇ ଆକ୍ୟୁଜ ଟା ତାକୁ ଷ୍ଟିକ ରେ ମାରଲା ଆପଣଙ୍କର ଆଇ ୱିଟନେସ୍ ଥିଲା ଆପଣ ଗୋଟେ ସ୍ପେସିଫିକ ନଉଛନ୍ତି ଏ ଲୋକଟା ଷ୍ଟିକ ରେ ମାରଲା ବୋଲି ଷ୍ଟିକ କାହା ହାତରେ ଥିଲା ବୋଲି ଅନ୍ୟ ଆଇ ୱିଟନେସ୍ କହୁନାହାନ୍ତି ଆପଣଙ୍କର PW9 କହୁନି 19 କହୁଛି 19 କହୁଛି ଷ୍ଟିକ ଅଫ୍ 20 ବି କହୁଛି ସିଏ କହିନି କେବଳ ଆଉ ଅନ୍ୟମାନେ କହିଛନ୍ତି ଯେ ଜେନେରାଲି assault ହେଲା ଏଇ ଗୋଟେ ଲୋକ ସ୍ପେସିଫିକାଲି କହୁଛି and you come to the medical evidence that is PW18 even though the one injury is there lacerated wound on the scalp that is injury number 4 but the doctor's opinion is that multiple injuries caused by sharp and heavy weapon. Acha, ये injury to us, 4-5 injuries are अच्छी. What is the criminal antecedent?
Cause of death is due to heavy shock and hemorrhage due to multiple injuries caused by sharp and heavy weapon. That is the cause of death has been opined by the doctor.
Trial court has not dealt with anything.
I see how many
Kali's 14.
learned counsel for the petitioner, learned counsel for the state, learned counsel for the petitioner subject that the petitioner is in judicial custody since 26/6/2020. And though there are 4 eyewitnesses to the occurrence, that is PW9, 14, 19, and 20, but except PW14, the other eyewitnesses have stated in an omnibus manner that the petitioner, along with the other co-accused persons, assaulted the deceased, Digambar Sahu, by different weapons. The PW14 has stated that the petitioner has used one stick to assault the deceased, but he has not stated on which part of the body such assault was made. The Grand Council submits that another co-accused who has used iron rod is absconding and in view of the available material on record, there are good chances of success in the appeal and balance of convenience is in his favor. Therefore, the bail application may be favorably considered. Learned counsel for the state, on the other hand, place the evidence of the 4 eyewitnesses, so also the evidence of the doctor bracket PW 18 who conducted post-mortem examination and noticed 2 chop wounds, 1 stab wound and a lacerated wound, out of which, and opined that the cause of death was due to severe hemorrhage and shock due to multiple injury caused by sharp and heavy weapon. Considering the submission made by the London Council for the respective parties, nature of evidence adduced during trial, period of detention in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioner on bail to allow.
Trial court has not dealt with the medical evidence at all.
Yes.
Not touched.
Yes.
PW 18 has not been considered at all.
Next item.
Item 35.
Mr. Biswajit Mahanti. The delay. What is the delay? 158. It's a life condition.
My lord. Page of 4
Declared. No, it's a acquittal judgment. So acquittal judgment, whether notice has been issued on condonation, delay condonation. And you are asked to obtain instruction whether any the state wants to prefer any appeal or not. Written instruction is taken on that also. ସେଦିନ ମଧ୍ୟ ଆପେଲାଣ୍ଟ କେହି ନଥିଲେ, ତା ପୂର୍ବରୁ ଅବଶ୍ୟ ଥିଲେ। Notice ଲେଖନ୍ତୁ IN number 3199 of 2024. This is an application for condonation of delay. The stamp reporter has pointed out that there is delay of 158 days in filing this appeal. Issue notice to the respondents. Land Council for the state accepts notice on behalf of the respondent number 1. आपन पाहिर appeal memo अछि तो?
Appeal memo.
और से interim application copy अछि?
Nine.
Let a copy of the interim application be served on the London Council for the state. So far as respondent number 2 is concerned, the requisites for issuance of notice by speed post with proof of delivery shall be filed by 16th of May 2025. Matter will be listed in the week commencing from 30th of June 2025. Objection, if any, to the delay condonation application be filed in the meantime. Your colleague in